Entrance one number, secret code. Serial number 45.
45.
45.
ಯಾವ ವರ್ಷದ್ದು?
24.
24.
The place of part accommodation.
Last one.
45, last one.
ಕೊಡ್ಬೋದಾ? All right.
Entry model.
2 weeks. Entry mod to continue for 2 weeks only. Yes. 43. 2024. All right. 2 weeks. Entry mod ಇದೆಯಾ? Second ಮುಗಿಬೇಕಲ್ಲ. ಇದೆಯಾ? Entry mod to continue for 2 weeks only. ಹಂಗೆ ಮಾಡ್ಬೇಕು ಇನ್ಮೇಲೆಲ್ಲ. Okay.
Serial number 31, 32, Maharaj.
31, 32.
Request for 2 weeks time.
All right.
Serial number 40, my
2 weeks at the request of will go.
Achha.
33.
33. 23 matter. Last time ತೊಗೊಂಡಿದ್ರೇನು ಇದ್ರಲ್ಲಿ ಮತ್ತೆ ತೊಗೊಂಡಿಲ್ಲ. 2 weeks at the request of entry ಮಾಡಿದೀಯಾ? ಇಲ್ವಾ? All right. 3 weeks ಮಾಡಿ. 30. ಯಾಕೆ? Not well. All right.
Serial number 27.
Caller after 2 weeks on health ground of arguing counsel appearing for so and so.
Serial number 27, Maharaj.
27.
The substantive assistance in the hands of the appellant's husband have been settled.
Settled.
This
Okay.
becomes academic.
Counsel for the the petition appellant has moved the memo in the open court dated so and so in the open court seeking leave to withdraw the appeal
The appeal may be treated disposed of, Maharaj, because
to treat the appeal as having become infructuous. First up, memo reads as any objection from other side? On being asked, the panel counsel appearing for the revenue signifies his no objection. No objection in what's the act. First up, in view of the above, appeal is accordingly disposed of.
serial number 40, my lords.
40.
40. I'm for the appellant. I'm requesting for 2 weeks time to file paper book, my lords. I'm requesting for a date in the second week of February.
First you file the paper books.
Please, I will file. It's almost ready.
Paper books to be filed within 2 weeks. Finally. Okay.
Great.
Call after 2 weeks.
Great.
First ಮಾಡ್ಬೇಕು. Yes, next. Paper book ಹಾಕಿಲ್ಲ, date fix ಮಾಡಿ ಅಂತ ಹೇಳ. Yes.
Your Lordship,
Will goals matter? Whether liberty should be reserved or not. ಮತ್ತೆ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಿ Okay. ಅದ್ ನಂಬರ್ ಫೈಲಿ ಕಳ್ಸು.
Your Lordship, may I mention item 37, 38, 39?
37, 38, 39.
Yes, Your Lordship.
What we have read these papers.
Your Lordship, I request for 4 weeks time to file my objections
Objections to?
to the affidavit, additional affidavit filed by the appellant department, Your Lordship, to the confirmation.
As you filed additional affidavit. You have filed it. We're calling. 2 weeks. At the,
Connected matter. I'll give the connected.
ಇದು ಉಪಯೋಗಿಸ್ಬೇಕು ಮೊದಲೇ ನಿಮ್ ಗೌರ್ಮೆಂಟ್ ಕೇಸ್ ವೀಕ್ ಇರ್ತಾವ ನಿಮ್ ಲಾಯರ್ ವೀಕ್ ಇರ್ತಾವ.
My lords, another 4 appeals are there. I'll give the numbers, my lords. It has to be posted along with
Call
that.
after 2 weeks along with the ITA number so and so.
Please.
Your Lordship, may I request for 3 weeks if possible?
All right, 3 weeks.
Much
All
obliged.
All right.
My lord, serial number 26, my lords,
26.
for the respondent, my lord.
Ah.
I mean, a week's adjournment, my lord.
ಯಾಕಿದು
ಇಲ್ಲ, senior is
2009
unwell, ಅದಕ್ಕೆ ಇವತ್ತು ಬರ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಕೃಷ್ಣಮೂರ್ತಿ sir. So,
ನಾಟ್ ವೆಲ್
yeah, he
ಅಥವಾ
has some
ನೀವೇ ಅವ್ರಿಗೆ
function-
ಆರಾಮಿಲ್ಲ ಅಂತ ಮಾಡ್ತಾ
ಇಲ್ಲ, ಇಲ್ಲ, he has some function in the, this,
Ah.
next week, a date may be
26 call next week finally at
Yes.
the request of
a date may be fixed.
ಆ ಪೋಸ್ಟರ್ ಆಗ ಆರ್ಗ್ಯೂ ಮಾಡಲ್ಲ ಟೈಮ್ ಕೇಳೋದು ಡೇಟ್ ಫಿಕ್ಸ್
ಇಲ್ಲ, that just,
ನಥಿಂಗ್ ಲೈಕ್ ದಟ್ ನೆಕ್ಸ್ಟ್
Thank
ನಾವು ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಅನ್ಕೊಂಡು ಓದ್ಕೊಂಡ್ ಬರ್ತೇವೆ ಅದನ್ನ ಟೈಮ್ ತೊಗೊಂಡ್ಬಿಡೋದು. ಎಸ್ ಏನದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ಸ್
Lordship,
Comply ಮಾಡಿ.
Complaint.
2 weeks for compliance of office objections, failing which petition runs risk of dismissal on that ground per se. Next.
Appearing for the appellant.
Ah,
Pay for a week's time to file the submission, maybe listed the week after next month, we file it by that time.
call week after next, the request of counsel for the appellant. Finally.
My lord, in this matter.
Want to withdraw the,
For
withdraw the
withdrawal,
appeal?
my lord. Yes, my lord, regarding the rectification of.
Sorry. Office objection is overruled. Counsel for the
Filed under Vivas scheme, my lord, we need to withdraw.
has
and
filed
submit.
seeks leave of the court to withdraw the appeal. First off, memo reads as under. Memo ಇದೆ ತಾನೆ?
Already I filed a memo for withdrawal, my lord.
ಇದೆಯಾ?
Yes, my lord.
ಇಷ್ಟಕ್ಕೆ ಉತ್ತರ ಏನ್ ಹೇಳ್ಬೇಕು? ಎಸ್ ಅಥವಾ
Yes,
ನೋ?
my lord. Yes,
ಅದ್ರ ಮೇಲೆ ನೀವು need not write an epic like
Yes, ma'am.
Ili Dodisi. Memo seeking leave reads as under. First off, any objection from your side? On being asked, comma, the panel counsel appearing for the revenue signifies his consent for grant of leave. First, in the above circumstances, appeal is disposed of
With liberty to revive, my lord.
as
In case-
with liberty as sought for in the memo.
Please.
Signature ಮಾಡಿ
Signature, I will sign it.
ಕೊಡಿ.
Much obliged.
Yes. For same,
Please, please.
ನೋಡಿ, ಸೇಮ್ ಆರ್ಡರ್ ಆ ರೀತಿ ಮಾಡ್ಕೋಬೇಕು, ಡೇಟ್ ಎಲ್ಲ ಬರ್ಕೋಬೇಕು ಮೆಮೋದ್ದು.
The leave may be granted, my lord, in this also,
ವಿತ್ ಲೀವ್.
please.
ವೆಂಕಟೇಶ್,
Appearing for the application.
Ah.
Completed.
ಸರ್ವಿಸ್ ಇಸ್ ಕಂಪ್ಲೀಟ್.
I don't
Have
have.
applied.
ಯಾವ ರಿಸೀವ್?
Can you give me a copy?
ಅವ್ರಿಗೆ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ,
ಕೊಡ್ತೀನಿ sir.
2 ಕಾಪಿ ಕೊಡಿ. Shri Aditya Vikram Bhatt, learned DGA, on request accepts notice for respondent number 1. First off, petitioner to serve a set of petition along with a copy of petition along with all the documents on him.
Interim order maybe.
In 19 to 23 ಏನದು? All right. ಅಲ್ಲ ಡೇಟ್ ಇತ್ತಲ್ಲ, ಯಾಕೆ ಬಂತು ಡೇಟ್ ಅಂತ? All right. Interim order to call after 4 weeks, interim order to continue. Survival. Okay. Second or sir? All right. All right. Okay.
My lord, this is appeal by BBMP, my lord. It's come on process. My lords, may kindly permit me to serve the copy on the counsel, Hegde Shripad Gangadhar, who is filed contempt, my lord.
ಬರ್ಕೊಳ್ಳಿ. ಶ್ರೀ ಎಂತ ಹೆಗಡೆ?
Hegde Shripad Gangadhar.
ಶ್ರೀಪಾದ್ ಗಂಗಾಧರ್ ಹೆಗಡೆ. Learned panel counsel Shri Shripad Gangadhar Hegde is requested to accept notice for respondent number,
Sole respondent.
the sole respondent. First, petitioner to serve copy of the appeal memo along with all the documents on him immediately.
Obliged.
Call after 2 weeks.
Much obliged.
Sanmati.
Lordship, he is taking notice for the respondent. I received the wakalat, Your Lordship.
Shri so and so accepts notice for the respondent SSC. First off, call after 4 weeks. 4 weeks? Call after
Lordship,
4 weeks.
Your Lordship, there is delay of 105 days, it may be condoned.
Delay condone ಮಾಡೋಣ?
Salute, Your Lordship.
ಅಲ್ಲಿ ನೋಡಮ್ಮ. Appeal is filed after brooking a delay of 105 days. First off, an application is moved seeking condonation thereof, and it is supported by an affidavit. First, next paragraph. Learned counsel appearing for the SSC objects to the condonation of delay orally. First, having heard learned counsel appearing for the parties and having considered the application seeking condonation of delay, comma, we are of the view that the explanation offered is plausible and therefore delay needs to be condoned. First, application is allowed delay is condoned.
Your Lordship, transfer pricing issues are involved. Question 1 to 4 at page number 5 maybe.
Same being debated in that one. We are, those questions are actually. Berkeley. Appeal is admitted on substantial questions of law at serial numbers
1 to 4 questions, my lord, at page number 5.
1 to 4. Which read as under, ಅವನು reproduce ಮಾಡ್ಬೇಕು. ನಮ್ಗೆ ಸ್ವಲ್ಪ ಒಂದು ಪೆನ್ ಡ್ರೈವ್ ಇಂತ ಕೊಟ್ಬಿಟ್ರೆ ಅದ್ ಮಾಡಿ ಹಾಕ್ಬಿಡ್ತಾರ ಅವ್ರು. ಮತ್ತಿಲ್ಲಪ್ಪ ಅದನ್ನ ಅಷ್ಟು ಹ್ಯಾಂಡ್ಸ್ ಇಲ್ಲ ನಮ್ಗೆ ಅದಕ್ಕೆ.
Share it, my lord.
Okay. Admit. Yes.
Your Lordship, 8, my lord, annexure e-translated copy I have not produced, my lord. It is not required, my lord. Your
Not
Lordship, the
required.
question whether 194 LA is.
Requirement of translation dispensed with on accepting the submission of learned panel counsel. What is
May
the
be
matter?
permitted to take out notice, my lord. There is delay, my lord.
All right. Emergent notice.
My lord, the caveat petition, what the office has made the note, my lord, is not pertaining to this prayer which I have made, my lord.
Anyway, he appears. na?
Caveat is there, my lord. I am
Ah.
serving a copy of my petition.
What?
My limited prayer was that this, my lord, is only to extent of time which the tribunal has directed me to deposit, my lord. Tribunal has
Yes,
directed
time back.
today, my lord,
Asking. Yes, time back.
I need about the 8 weeks time, my lord.
8 weeks.
No, my lord, in fact, 4 crores, please, my lord, please, please.
Since 2021 litigation is going on, my lords. DRT dismissed his appeal. He filed appeal before DRAT. It had already given him 4 weeks time for deposit of 2 weeks ಕೊಡ್ಬೋದು. For 8 weeks will be beyond.
3
March,
weeks.
my lord.
3 weeks.
ಕೊಡ್ಬೋದು.
3 weeks.
My lord, 4 weeks, my lord. 4 weeks, my lord. It is a
And after all, he.
4 weeks for the first payment of 2 crores, my lord.
ಒಪ್ಪಿದ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಕಳ್ಕೊತೀರಿ ಕೇಸು. ಯಾಕಂದ್ರೆ ನೆಗೆಟಿವಿಟಿ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ಅದಕ್ಕೆ. ಇನ್ನೊಂದು ಸಬ್ಸ್ಟೆನ್ಸ್ ಇರಲ್ಲ. ಅತ್ಲಾಗೆ. Anyway,
Please, my lord.
you don't want to leave?
No, please, my lord. Please.
Be seated. I'll pass.
Please.
ಏನು 4 weeks ಕೊಟ್ರಿ ಏನಾಗ್ತದೆ ಬರ್ಕಡೆ. Shorn of bulkiness of paper book, comma, the short grievance made out at the bar by the learned counsel appearing for the borrower is against the shortness of the period granted by the DRAT at Chennai for making pre-deposit for maintaining the appeal in terms of section 17 are there? 18 of so and so act. Act ಬರ್ಕೊಡಿ.
Surface Act.
Next paragraph. Learned panel, senior panel counsel appearing for the respondent bank vehemently opposes the appeal petition, contending that what time should be granted for making pre-deposit, comma, ordinarily pertains to the exclusive domain of the appellate authority, and therefore the interference of this court is not warranted. First, next paragraph. Having heard the learned counsel for the parties, kindly be seated, and having perused the appeal petition papers, we are inclined to grant a limited interference in the matter to the effect that 4 more weeks be accorded to the petitioner to make the pre-deposit for maintaining the appeal. First off, no prejudice would be caused to the other side by this exercise. First off, if such a relief is denied, comma, the borrower will be prejudiced and he will go home with a heavy heart. First off, that a writ court cannot afford to do. First off, in the above circumstances, petition having been partly favored, comma, petitioner is granted a period of 4 weeks for making the pre-deposit for maintaining the appeal in question. First off, till this is done, till 4 weeks expire, comma, no prejudicial order shall be made by the DRAT on the subject of appeal.
There is one more prayer, my lord. In fact, the DRAT has directed me to deposit this 2 crore rupees with the registry, which will be invested in the nationalized bank. So which will not be beneficial to me, my lord. In fact, I may be directed to deposit the money
In the bank
with the bank
itself.
so that my interest.
Very
will be reduced.
correct, you are right. Yes, it will be beneficial to you.
I don't have enough.
ಅಲ್ಲೇ ಬರ್ಕೊಳಮ್ಮ. The DRE, the amount being so deposited, comma, the DRAT shall remit it to the
It be directly ordered
account
to,
of the,
let it be directly ordered to deposit to the bank. my lord.
Petitioner may be
But,
directed to deposit with the respondent bank.
ಬರಲ್ಲ ಹಂಗೆ. ಆ ರೀತಿ ಮಾಡಕ್ ಬರಲ್ಲ. Condition is deposit in the registry, the section ಹಂಗಿದೆ ಅದಕ್ಕೆ. ಆ ರೀತಿ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದೇವನು. ಏನ್ ಬರ್ದಮ್ಮ? To the account of the bank account of the petitioner without broking any delay, so that such a deposit may inure to the benefit of the borrower. Okay. All contentions on appeal are kept open.
Much.
All other contentions on appeal are kept.
Much.
ಏನೋ ಒಂದ್ 2-4 ವಾರ ಕೊಟ್ರಿ, why these people matter comes like this? After all ಅವ್ರ ಏನ್ ಹೇಳೋದು? 1-4 ವಾರ ಕೊಡ್ರಿ. ಏನ್ ಕಳ್ಕೊಳ್ಳೋದಿದೆ? ಬ್ಯಾಂಕಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಅಕ್ರೂ ಆಗಿ ಆಗ್ತಿರ್ತದೆ.
If they had filed application, would there only wouldn't have objected.
Anyway, ಇಂಥ ಬಾಳ್ ಮ್ಯಾಟ್ರಸ್ ಬರ್ತಾ ಇದೆ. ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರ ಆಗಲ್ಲ, ಅದು ತುಂಬಾ ಮ್ಯಾಟ್ರಸ್ ಬರ್ತಾ ಇದೆ. ಎಸ್,
It appears to have been filed by the respondent, my lord.
ಹಾ
Respondent claims that they were on caveat
ಬರೀ
and therefore orders could not have been passed. But not the perusal of the order sheet shows that
all previous dates of orders.
matter is admitted on 24/5/2022. On that date, no caveat appears to have been put up. And thereafter, no representation for the respondent until 28/2/2023. Question, my lord, is one of
Once he dismiss ಮಾಡಿದ್ರೆ, he will face some difficulty at the hands of his client. Will say this IA will be considered along with the main matter.
much obliged.
IA to be considered along with the main matter. All.
Please. That's a funny memo for withdrawal.
Yeah, nobody is happy with the court or what? So many withdrawals,
Matter actually it's become infectious.
infectious. ಬರ್ಕೊಳ್ಳಿ.
Actually nothing.
ಬಟ್ ಕೇಸ್ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ ಅಂದಾಗ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಭಯ, ಯಾಕಂದ್ರೆ ಕೋರ್ಟ್ ಮೇಲೆ ಕಾನ್ಫಿಡೆನ್ಸ್ ಕಡಿಮೆ ಆಗಿದೆ.
ಆತರ ಇಲ್ಲ.
ಹಂಗ ಆಗ್ಬಾರ್ದು ಅದಕ್ಕೆ. ಬರ್ಕೊಳ್ಳಿ. The counsel for the appellant assessee has moved a memo seeking leave of the court to dispose of the appeal, leave of the court, stating that the appeal has become infectious because of changed circumstances. First, memo reads as under. Next paragraph. Learned counsel appearing for the revenue, panel counsel appearing for the revenue signifies his consent to the grant of leave. First up, in the above circumstances, appeal is disposed of as having become infructuous in terms of memo.
Obliged. Great.
Ordered accordingly.
Here what had happened was an application for condonation of leave.
Delay condone ಮಾಡೋಣ ಬರ್ತದೆ, 339 days ಇದೆ.
My objection may be recorded.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲಲ್ಲ ನೀವು?
ಹಾಕಿದ್ವಿ.
ಹಾಕಿರಾ? ಏನಂತ ತಗೊಂಡ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡಿ. ಬರ್ಕೊಳ್ಳಿ. This appeal, this petition is moved after broking a delay of 339 days. First, seeking condonation of same, an application support in IA number 1 of 2023, supported by an affidavit is moved. First, the assessee has filed his objections resisting the application. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are of the considered view that the explanation offered for the delay in question is plausible and therefore merits acceptance. First up, we also add that more older matters than this are languishing in the cupboards of the court, and therefore it is not that had the petition be filed in time, it would have been taken up for consideration and disposed of too. Full stop. Next, in the above circumstances, application is allowed, delay of so many days is condoned.
Lord's matter pertains to burden of proof under section 70.
The same Supreme Court order.
Yes, question of law is framed, is proposed on page 12, my lords, paragraph Roman 8. If your lordship are
But,
pleased to consider matter
Petition
posted
is
finally.
admitted on the, it's only question of law, on the question of law framed at
Para Roman 8. page
para
12.
Roman 8 of the petition. Petition, comma, in view of decision of the apex court in
Ecom Gill, my lords.
Barkodi. So
Ecom
and
Gill
so, so and so.
versus
First
Gill.
one, the said question reads as under. Okay. Next. ಎರಡು ಸೇಮ
ಒಂದ್ 4 ಆಯ್ತಿದೆ ಸರ್.
ಆಯ್ತು 1 2 3 4 5 ಆಲ್ ನೋಡಮ್ಮ ಸೇಮ್ ಕ್ವಶನ್ ಸೊ ಆಲ್ ಸೆಟ್ ಓಕೆ appeals are admitted.
Lordship, there is
ಮತ್ತೆ
185 days delay, my lord.
Huh?
85 days.
ಡಿಲೇ ಇಲ್ದಂಗ್ ನೀವು ಹಾಕಕ್ ಆಗೋದೇ ಇಲ್ಲ ನಾವು ಮೋಸ್ಟ್ಲಿ
Because
ಸುಮ್ಮನೆ
your lordship, this
ಸೆಕ್ಷನ್ ಸ್ಕ್ರಾಪ್ ಮಾಡಿದ್ರೆ ಆಗ್ತದೆ ನಿಮ್ಗೆ ಯಾವ ಬೇಕೋ ಹಾಕೋಬಹುದು ಅಪೀಲ್
2023 ಅದು ಕೋವಿಡ್ ತನಕ 22 ಇರೋದನ್ನೆಲ್ಲ ಬ್ಯಾಕ್ಲಾಗ್ ಜಾಸ್ತಿ ಆಗೋಯ್ತು ವರ್ಕ್ 23 ಇಂದ ಆನ್ವರ್ಡ್ಸ್.
ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋಣ. You got a good friend, she very graciously says condone delay. Parkali. Appeal is moved, appeal is filed after brooking a delay of 185 days. Full stop. An application supported by an affidavit accompanies the same, comma, for its condonation. Full stop. Counsel appearing for the assessee opposes the application, saying that there is no ground for condonation of delay. Full stop. Next paragraph. Having heard the learned counsel for the parties and having perused the petition appeal papers, we are of the considered view that delay is short and its condonation would not cause any prejudice to the other side. First stop. Conversely, if delay is not condoned, appellant would be put to a manifest injustice. First stop. Allon sentence ideyalla. Older appeals than these are still pending ant. A sentence add sentence hakonbidಬೇಕು. Next part, in the above circumstances, application is favored and delay is condoned.
Lordship, transfer pricing issues are involved, my lord.
Same.
Same.
Which are the questions?
1.1 to 1.9.
Nodama. Appeal is admitted on the following substantial questions of law. 1.1
1.1 to 1.19. 1.9, my lord.
9. Correct, Tobek. The similar questions are being debated in appeal number
Your lordship,
in a few appeals.
yes,
A
my
few
lord.
appeals. Full stop. Therefore, the above questions are accepted as the substantial questions of law for treating the appeal in question. Okay. Next paragraph. ಅಲ್ಲೇ ಅವನು ಇದನ್ನ ಮಾಡ್ಬೇಕು ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋ ಕ್ವಶನ್ ಓಕೆ ಹಾ
This is also similar, my lord.
ಸೇಮ್ ಆರ್ಡರ್
Same transfer pricing case, my lord. Question 1 to 4.
No, no,
Delay ಗೆ
Be recorded in this. I filed my objections.
ಸೇಮ್ ಯು ವಾಂಟ್ ಟು ಫೈಲ್
I
ಅಬ್ಜೆಕ್ಷನ್
have
it's
filed my
already filed.
ಫೈಲ್ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಟ್ ಸೇಮ್ ಇದೆ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಆಲ್ರೈಟ್ ಸೇಮ್ ಆರ್ಡರ್ ಕ್ವಶನ್ಸ್ ಆಲ್ಸೋ ಸೇಮ್ ಓಕೆ ನೆಕ್ಸ್ಟ್
Much obliged, my lord.
Delay can be condoned. There's a 187-day delay.
Okay. A delay of 187 days is proved in filing the appeal, intra-court appeal. First director. A plausible explanation is shown for the same. First stop. In view of that, application in IA number 1 of 2023 is favored and delay is condoned. Okay.
Sometime next week or even later this week is.
Week after next. Call this matter week after next at the request of learned AGA. Sanmati.
Your lordship, if my learned friend will take notice for the respondent, my lord. Assert the copy, my lord.
Notice. Learned counsel Shri so and so accepts notice for the respondent assessee. On 32 days ಇದೆ delay ಕಂಡೋನ್ ಮಾಡೋಣ. A short delay of 32 days is proved in filing the appeal and the application in IA number 2 of 2020, IA number 1 of 2025 accompanied by affidavit is moved seeking condonation thereof. First, cost shown being reasonable, comma, application is favored and delay is condoned. Okay. Up call after 2 weeks. Well, ಕೆಳಗಡೆ office objection is complied with. And ಮೇಲ್ಗಡೆ first line office objection complied. 17.
IA2
Yes,
may be left
sir.
open, man.
Huh?
IA2 may be left open.
ಅದಕ್ಕೆ ಅದು ಇಷ್ಟ ಮಾಡಿದ್ದೇವೆ ನಾವು ಈಗ ಬೇರೆ ಏನ್ ಮಾಡಿದ್ವಿ.
Apply.
Yes.
What is it? I for the response.
Covered.
The issue relates to demand of entry tax on base oil. This honorable court for the earlier period has already decided the matter.
Appears that. Correct. The subject matter of this petition is substantially similar to the one in TAET, correct? Number 10 of 2014 between so and so versus Additional Commissioner of Commercial Taxes, heard and disposed of by a coordinate bench of this court, wide judgment dated 16/12/2020 in terms of ಯಾವ judgment, apex court judgment ಯಾವ್ದದು? Collector of Central Excess Alluri.
Terms of judgment of this trial, I mean, this honorable court.
Full stop. Granting holding in favor of the assessee. Assessee.
Appeal against it is pending before Supreme.
Full stop. We are told that the appeal against ಯಾವ್ದದು?
This judgment.
Against this judgment is pending on the file of apex court in SLP number
6045 of 2020. I'll just go.
6045 of
2022.
2022. Full stop. In view of the above, this petitioner is disposed of subject to outcome of the pending SLP before the apex, pending SLP. Full stop. In the event SLP is allowed, it is open to the revenue to seek revival of this petition. Okay. Comma, subject to all just exceptions. First, ordered accordingly and petition is disposed of. Report ಇದೆಯಲ್ಲ, report ಕೊಡಕ್ ಬರಲ್ಲ ಅನ್ನೋದು, report ಡೆಲ್ಲಿ ಅಂದ್ಕೊಟ್ರೆ ಈಸಿ ಆಗ್ತದೆ. ಇನ್ನು ಆ ಡೈರಿ ನಂಬರ್ ಬರ್ಸ್ಕೋಬೇಕು. ಆಲ್
Appear for respondent.
ಹಾ
Raise 3 questions, Lord.
ಹಾ
In common section, it is only one question, Lord. It is the corporation. They will just land to the court.
ನಿಮ್ ಕಡೆ ಹೇಳ್ಕೋಬೇಕು.
Your Lordship, respondent is a corporation, my lord. They will get
Respondent is a corporation. Full stop. Next,
they will get grants from the government.
they will get grants from the government.
Government, some funds from the government. They will park those funds in the bank to get interest before utilizing that.
One second, repeat. They will get interest
They will get interest on that
because they
deposits.
park that money in the bank.
The bank.
Okay.
We are saying that is, has to be taxed under the head, other income under section 56.
Like our deposits.
Our deposit. But this honorable court has taken, has held against revenue in similar case, my lord, that has been followed by the tribunal. It is held against revenue. It doesn't.
ಯಾವ್ದದು?
Addition.
May I pass on?
ಕೊಡಿ. ತಿಳ್ಕೊಳ್ಳಿ.
I prepare compilation page 20, in page 20,
In page 20.
in page 20.
This has been referred to by the tribunal at paragraph paragraph 3.4, page 15, my lord, of the appeal memo.
Appeal was filed by you or them?
No, it was before tribunal also, it was their appeal.
So yeah, two authorities have held in your favor. Two or three?
Two authorities.
Two authorities
Can I
have
come
held in
first?
your favor.
The interest, I don't get that. It will go to the government account. It is again treated as a money.
It
given.
goes back to,
Yes, that's why they said that it's not mine.
Your lordship can close it as covered, my lord.
the subject matter of this appeal is substantially similar to the one heard and decided by a coordinate bench of this court in ITA number
Your lordship, 2418 of 2005.
2418 of 2005.
Five. In the case of Commissioner,
Wide between so and so. Kodiyadu.
Commissioner of Income Tax and another versus Karnataka Urban Infrastructure Development and Finance Corporation.
Corporation. First off, the judgment is dated
Your lordship, it is dated 21st February 2006.
21st February 2006.
Paragraph 4 extract.
And it goes in favor of the assessee, wherein paragraph 4 reads as under.
Yes.
4
of that judgment, my lord, relied upon judgment.
4 of said judgment reads as under. Next paragraph. In view of the above, this appeal being unmeritorious is liable to be and accordingly rejected.
Your lordship may kindly pass separate order, my lord.
ಎಲ್ಲದಕ್ಕೂ
18, your lordship,
Separate
the similar order may be passed in 18.3 also.
18.3. ಇದು 18 point
Your lordship, 18 point, first matter, my lord, 495 of 22.
ಒಂದು ನಿಮಿಷ 18.18
18 minutes, 490.
18 ನಲ್ಲಿ ಮಾಡ್ಬೋದು ಈ ಆರ್ಡರ್ ಅನ್ನ
This order, my lord.
18.2 ದಲ್ಲಿ ಮಾಡ್ಬೋದು
18.2 ಬೇಡ, 3.
ಬೇಡ 18.1 ಏನು
18.1, my lord, your lordship can only, the questions of law raised in this case does not arise for consideration and liberty may be reserved to urge these questions in the,
some other
in the first matter, my lord.
ಬರ್ಕೊಳ್ಳಿ ಇನ್ನೊಂದು 18.1 ಹೇಳ್ತಾ ಇದೆ ನೋಡು ಇದನ್ನ 18 ಮತ್ತು 18.3 ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್ 18.1 18.3 ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್ ಬರ್ಕೊಳ್ಳಿ ದಿ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ 18.1 ದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಕರೆಕ್ಟಾ
Yes, my lord.
the substantial questions framed by the revenue seeking admission of this appeal on that basis do not arise for consideration.
Yes, my lord.
First off, in view of the above, appeal is dismissed. First off, however, the said questions may crop up in some other matter.
Your lordship,
as
in
the
first matter, 495 of 22.
crop up in some other matter. First off. Okay. Next, disport of 18.2 na
Same order, ಅದೇ 18.1 similar.
18.1 type ಅದರಲ್ಲಿ ಹೇಳಲ್ಲ
Your lordship, 18.1, 18.2 does not arise.
ನೋಡಮ್ಮ ಸೇಮ್ 18.1 18.2 ಸೇಮ್ ಆರ್ಡರ್
18.3.
ಎರಡು they have to be held against you on merits.
Yes, my lord.
ಇನ್ನೆರಡು the questions themselves do not
Does not
arise.
arise.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು ಅದು ಪ್ಯಾರಾಗ್ರಾಫ್
Compilation ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾನು
ಒಂದು ಫ್ಲಾಪ್ ಹಾಕ್ಬಿಡಿ
separate ಆಗಿ ಕೊಡಿ.
ಫ್ಲಾಪ್ ಹಾಕಿ ಪ್ಯಾರಾ 4 ಅಲ್ಲ
Para 4.
ಓಕೆ ಅದು ಫಾಲೋ ಮಾಡಿ ನಾವು ಏನು ಬರ್ದೇವೆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಬಟ್ ನಾನು ಒಂಚ ಎಸ್ 19
My lords, in 19, my lords, these appeals are already admitted, my lords, on 6th February 2023.
ನೋಡಿ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ ಅಪೀಲು
Lords,
ಇದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅನ್ಬಾರ್ದು ಇದಕ್ಕೆ ಅಡ್ಮಿಷನ್ ಅನ್ಬೇಕು ಭಾಳ ಡಿಫ್ರೆನ್ಸ್ ಇದೆ ಎರಡಕ್ಕೂ
Lords, what had happened, my lords, these were admitted subsequently because of monetary limit circular was issued, my lords. All these matters were.
ಆಗಿದೆ ಅಲ್ಲಿ ನೋಡಿ these appeals are admitted by a coordinate bench of this court wide order dated 6/2/2023. First off, ಮತ್ತದು ಮಾನಿಟರಿ ಲಿಮಿಟ್ ಏನಾಗ್ತದೆ?
My lords, this is our above monetary limit, my lords. These appeals are maintainable. That is the reason.
The other appeals which were below monetary limit,
Those were
given
How
that
dismissed of appeal?
that got posted, these also came back.
Registry to note the same and post the matter for hearing in regular course. Okay. Ah,
20 also same, my lords.
same order, huh?
Is admitted
On?
on 3rd January 2023.
Nodama, same order, okay. Ah,
Oblige.
ah,
My lords, appeal against an order of the tribunal.
ah.
Question is whether non-dairy whip topping,
Non-dairy,
non-dairy whip topping is eligible to
ಏನದು actually?
ಅದನ್ನ ವೆಜಿಟೇಬಲ್ ಫ್ಯಾಟ್ಸ್ ನ ತಗೊಂಡು ಒಂದು ಕ್ಯಾನ್ ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ. ಅದು ಕೇಕ್ ಮಾಡೋದಿದ್ರೆ
ಉಪಯೋಗಿಸ್ತಾರೆ ಮೇಲ್ಗಡೆ ಹಾಕಿ.
ಅದ್ರ ಮೇಲೆ ಸ್ಪ್ರೇ ಮಾಡ್ತಾರೆ ಅಥವಾ so there is a notification relating to whip topping, dairy products, etc. 197 of 2005 dated 34/2005, my lords. Question arise, thereafter there is a, your lordships may kindly see in the order of the tribunal itself, a clarification by the commissioner is available at page 46.
46. Ah. This is a statutory clarification.
My lords. And
It is clarified that non-dairy whip topping is liable to tax at 4% as an industrial input from 1/4/2005 to 30/4/2005.
then thereafter, it is said to be taxable from 1/5/2005 to
At 12.5%.
12.5
Then at
and
13.5%.
13.5, my lords.
Ah.
The tribunal, my lord, proceeding in isolation of this, merely says that at some point in time, I have treated this as a input. And therefore, the exemption is to, as an industrial input, and therefore the exemption is to continue
Continue. For that period also.
for all periods, my lords. Even period that is provided for in my notification for increased rate of tax.
How this is treated at what page they have treated this?
Your lordships may kindly see,
ಒಂದು aspect ಬೇಕು ನನಗೆ. Suppose ಈ notifications, so clarifications ಅನ್ನು produce ಮಾಡ್ತೀನಿ appeal ನಲ್ಲಿ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ. ಹೌದಾ? Tribunal ಮುಂದೆ. Whether this notification is right, whether it is invocable or not, definitely one can argue. Whether this is legally sustainable or not issue, argue ಮಾಡ್ಬೋದಾ appeal ನಲ್ಲಿ? ಅದನ್ನು ಮಾಡ್ಬೋದು. Even the clarifications.
before your lordships.
Not before us. No, this is again petition, what comes from there is not a writ court.
This is not a rate code.
It's a revisional court.
It's a revision, my lords.
Therefore, we are asking whether can we decide the sustainability of these statutory instruments before us. Invocability, yes. It's a law.
It's a law.
It's a subordinate legislation. That's what Justice Oka Sahib has held that Supreme Court. That can be argued is true. But can it be said in the revisional jurisdiction, this is unsustainable? Is it your case? No, it's not your case.
No.
Need not
One
answer.
question that may arise is whether a notification that is dated 22/5/2010 can, in retrospect, apply from 23/3/2005, etc. From 2005 itself,
23.
22/5/2010. That is the, your lordships may see on page 46.
46. Huh. ಏನಿದು? ಅಲ್ಲ, if it is a clarification,
Okay, precisely. That is my case.
If it is only pure and simple clarification of what is existing norm.
That is my case. That is my case. I go down, my lord. That is my case. Your lordships may see on page 58.
Suppose in the guise of clarification, some new norm is sought to be enforced.
Your lordship may see page 58, internal page 45 of the tribunal's order, ink page 58, para 43.
Moreover,
As already observed, the goods that is non-dairy whip property is considered as industrial input by the Learned Commissioner of Commercial Taxes in clarification number so-and-so dated so-and-so in terms of notification. But there is no basis for the Learned Commissioner of Commercial Taxes to clarify the rate of tax at 12.5% from so-and-so to so-and-so and rate of tax 13.5% from so-and-so, because government of Karnataka neither increased the rate of tax nor treated the non-dairy whip topping as non-industrial imports. Above all, even the Learned Commissioner of Commercial Taxes himself has not clarified or considered treated the goods as non-industrial imports for it to come under residuary entry as per notification dated 34/4/2005. Hence, we can safely conclude that the goods that is non-dairy whip property is industrial imports in terms of notification dated so-and-so. What happens, my lords, is that this is a finished product in itself. And that is the basis. And my lord, it does not
on
qualify.
what basis he says? E period ish percent tax, next period ishtu, mattond period. What is the basis?
Residual tarstar.
Huh?
He brings it into the residual category.
Then it will not be clarification only. Clarification, at least Justice Ravindran said in one matter, clarification ordinarily means throwing light on what is existing and is in obtainment. What is the base? If he is saying, suppose if there is some material to show that this was the case even earlier, that is being clarified, we can understand. In the guise of clarification, if he does certain things for the first time as a new norm, that would prejudice the assessee. Then it cannot be. You can do it with retrospective effect also.
My lords.
Which is that section which gives the power to clarify?
Section 262.
Or the norms, how that power to clarify, how that jurisprudence is developed. Which is the first judgment, which is the latest judgment on that.
The lordships may kindly see section 59.
Sorry.
Karnataka VAT Act.
After 2 weeks, actually, now we will also read and come back. I do not know much about this concept at all. The latest, one of the finest judgments, but Ravindran Sahibar Badr Bala Hinde. Call after 2 weeks. Full stop. Agenda so motum.
For the petition, entry tax matter, my lords, statutory revision. My lord, the connected matters are at serial number 35 and 36. And my lord has already passed an order of admission and framed the questions. Also stay in that serial number 35. This is that matter.
22 ಮತ್ತು 35
Up to 22 has today come for admission. 35 ಈಗಾಗಲೇ 4 matter ಇದೆ. 35.
ಹಾಗಾಗಿ ಅದ್ರ ಜೊತೆ ಆಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ
And also may I seek indulgence, my lord. I'm sorry, I was not present here at serial number 5. My colleague was here. That serial number 5 also has to get connected.
ಇದ್ರ ಜೊತೆನೆ ಮಾಡ್ಬೇಕಾ? The revision petition ಇದನ್ನ ಮತ್ತು serial number 5 or is admitted on the following question of law.
Serial number 5 is already admitted.
ಒಂದು ನಿಮಿಷ.
Yes.
ಅದಾಗಿದೆ ಈಗ.
ಆಗಿದೆ.
ಇದು ಒಂದರಲ್ಲೇ ಮಾಡ್ಬೇಕು.
ಇದು ಒಂದರಲ್ಲಿ
ಅದನ್ನ ಕಾಲ್ along with ಆಗ್ಬೇಕು. Call this matter and serial number 5 along with serial number 35. After 2 weeks?
Yes.
After 2 weeks.
But in this matter,
ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
yes, admit and interim order and the questions.
ಅಡ್ಮಿಟೆಡ್ ಆಯ್ತಲ್ಲ ಈಗ order
Yes, questions and also.
on the following question. ಒಂದೇ question
ನಾಲ್ಕು questions.
on the following 4 questions of law.
All right. My learned friend's office can also give me a copy
copy
with 5 along with 20. ಇದರಲ್ಲಿ ಇಲ್ಲ, 35 ಇದೆ.
Interim order as prayed for till next date of hearing. ಆಯ್ತಾ? ಇದನ್ನ serial number 5 ಎರಡನ್ನು 35 ಜೊತೆ ಕರಿಬೇಕು after 2 weeks.
And also 36. 36
It's
ಒಂದೇ
also-
ಬಂದ್ಬಿಟ್ಟಿದೆ. 35 ಅಲ್ಲಿ 4 ಮ್ಯಾಟರ್ ಕನೆಕ್ಟ್ ಆಗಿದೆ. 36 ಒಂದೇ ಸ್ಟ್ಯಾಂಡ್ ಅಲೋನ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Okay.
22 ಮತ್ತೆ
36 ಅನ್ನು ಕರಿಬಹುದಲ್ಲ?
yes. Your lordship is adjourning those two now only. Or should
ರೆಡಿ ಇದ್ರ ಅಲ್ಲಿ
ಇಲ್ಲ.
ಕಾಪಿ
ಆಗ್ಲಿ.
36 ನಲ್ಲಿ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಬೇಕಾ ಕೇಳಿ
stay ಇದ್ರಲ್ಲಿದೆ.
ಅದರಲ್ಲಿ
Let's stay
ಈಗ ಇದರಲ್ಲಿ 22
ನಲ್ಲಿ
ದಲ್ಲಿ ಮಾತ್ರ
questions of law framework.
ಓಕೆ.
And 5 and 23, my learned friend's
5,
office.
22, I'll give copies. my lord.
ಕೊಡಿ.
35 and 36 along with all these matters, your lordship is calling after 2 weeks. Great.
ಅಲ್ಲ ಇಫ್ ಯು ಆರ್ agreeable, if you want to argue we'll ready.
No urgency. My friend also has to get.
Okay.
Great.
ನಮ್ಗೆ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೇಕು ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ಸ್, ನಮ್ಗೆ ಅಷ್ಟು ಎಕ್ಸ್ಪೋಜರ್ ಇಲ್ಲ. ಹಾಗೆ ಸಮ್ ಎಲಿಮೆಂಟರಿ ವರ್ಕ್ ಮಾಡಿವಿ ಅನ್ನೋದು ಬಿಟ್ರೆ ಜಸ್ಟ್ ಗೊತ್ತಿಲ್ಲ. ಹಂಗಾಗಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೇಕು ನಾವು. ಉದಾಹರಣೆಗೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಹಂಗಂದ್ರೇನು, ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅದ್ರ ಮೇಲೆನೆ ಸಾಕಷ್ಟು ಕ್ರಾಫರ್ಡ್, ಕ್ರೇಸ್ ಆನ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ಸ್ ಇವರೆಲ್ಲ ಸಿಕ್ಕಾಬಟ್ಟೆ ಬರೆದು ಬಿಟ್ಟಾರ ಆಲ್ರೆಡಿ. GP ಸಿಂಗ್ ನಲ್ಲೂ ಇದೆ ಕ್ಲಾರಿಫಿಕೇಟರಿ ಲಾ. What is
Lord is probably referring to full bench judgment of Justice Ravindran, BHL matter.
correct? You are right. Yes.
Appearing for the respondent in this matter. my lord.
You are for the SSC.
Yes, my lord.
ಏನಿದು?
Matter pertains to whether your lordships had considered in another matter, if the input tax paid is not claimed in while filing the return,
In the very return itself,
nor the revised return
by amending the ಅಂತ ಉಪೇಕ್ಷಿದ್ರು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ.
within the
ಕುಮಾರ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್.
Centum versus State of Karnataka.
ಹಾ ಕರೆಕ್ಟ್, ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
My lords, there is, my submission is that there is no substantial question of law in this matter because here in my case, I am an SEZ unit. And
SEZ is not accessible to tax at all.
No, my lords, I am eligible to claim a refund. And this is only a procedural irregularity where I had not claimed it in my VAT 100, which is the monthly return, whereas I had claimed it in my VAT 240, which is the statutory report that has been filed by the auditor. Now, this has been settled by this very own Karnataka High Court decision in the case of Manyata Promoters, my lords. I am passing.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. ನೋಡ್ರಿ, ಏನೋ your young friend is saying something new. SEZ ಆಕ್ಟ್ ನಲ್ಲೇ ಬರುತ್ತೆ ಅನ್ನೋದು.
Yes, my lords. So SEZ.
ಆ ಆಸ್ಪೆಕ್ಟ್ ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಕುಮಾರ ಸಾಹೇಬ್ರ ಕೇಸ್ ನಲ್ಲಿ. ಬರೀ ಈ ಪ್ರಾವಿಷನ್ ಅನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು, ಹಾಕ್ಬಿಟ್ರು. ಅದ್ರಲ್ಲಿ ಹಂಗೆ ಇರ್ಲಿಲ್ಲ ಮೋಸ್ಟ್ಲಿ, ಹಂಗೆ ಮಾಡಿಲ್ಲ. ಮತ್ತೆ SEZ ನಲ್ಲಿ ಸಪರೇಟ್ ಎನೇಬಲಿಂಗ್ ಪ್ರಾವಿಷನ್ ಇತ್ತು ಅಂದ್ರೆ.
Respectful submission is that itself will constitute a question of law.
ಹಾ
Whether Manyata promoter applies and whether it can override the requirement under the VAT Act is, my lords, a question of law.
My lords, SEZ Act 2005 is a parliamentary act which overrides the state act, that is the KVAT Act. And this Manyata promoters, this Honorable High Court has held that refund is eligible, and merely because there's a procedural irregularity of not showing it in my VAT 100 does not debar me from claiming a refund. Also, the respondent's case is not that I am an SEZ unit, not that I am not eligible for refund claim. The only allegation or the only finding in the order is that I have not shown it in my monthly returns.
that you need not show because of statutory enablement is your contention.
And also SEZ Act overrides the state act, my lord.
Overrides ಅಂದ್ರೆ ಆ aspects ನಲ್ಲಿ.
Yes, my lords.
On the question of prior to the GST Act coming in force, in terms of the 3 schedules, questions of all matters of sale, tax other than income tax were with the state government. And administration, collection, enforcement
was also with the
is subsumed within that. with the coming into force of the GST Act that was facilitated by a constitutional amendment. The SEZ Act, my lords, is in order to give certain incentive for export of services, for example, software services, IT services, etc. A tax holiday was given. Now, where my statute applies, admittedly so, they pay the tax. The question is whether they're entitled to a refund or not. Are they exempt from complying with my law is the question. If the Supreme Court says so, my lord, that is another matter. Otherwise, my lord, this itself on whether.
What your infant says is,
My lords.
if central legislation enables her to take the benefit, regardless of claim being made in the return itself, regardless of revised return being filed, then decision of Justice Kumar will not be applicable, appears to be her submission. That appears to be sensible also. And that is considered by the judgment,
Yes,
by the coordinate bench.
yes, my lord.
Yavadu?
2016, my lord.
1 TMI.
1 TMI dated 39/2015.
Your
ಯಾವ
lordship,
paragraph ಇದೆ?
your lordship may kindly see paragraph 12.
6 ನಲ್ಲಿ questions frame ಮಾಡಿದ್ದಾರೆ.
Yes, my lord.
Para 6.
Para 6 are the questions framed and paragraph 12.
Paragraph 12, my lords.
Paragraph 12.
I shall start from paragraph 11, my lords, if my take my
Very-
lord's attention.
1 second, it is his.
Oh,
question.
obliged, all right.
No, this did not consider this Central Act at all.
This does not consider, my Lord Justice Kumar's judgment, which is decided on 31 July 2014.
Need not be. If under that act they are claiming the benefit, then Justice Kumar's judgment is applicable. If they are claiming benefit on the piece of central legislation, then they are entitled to, whether they amend, make the claim in the return or not, would pale into how that question is answered now.
My lord, kindly see, my lord, paragraph 12. My only submission is, in dealing with in dealing with section 35, the approach is somewhat technical, my lord. In the instant case, there is some delay in claiming refund of income tax because of many reasons. Refund of input tax cannot be denied on ground of belated claim. A reading of section 20 subsection 2, which is a beneficial legislation, makes it very clear that the developer of SEZ or unit located in any SEZ is entitled for refund of input tax credit or deduction from the output tax payable by such leader. Entitlement is there, my lord.
No period at all, no limitation period at all.
Section 22 does not contemplate any period within which such developer shall claim refund of input tax. Further, 130A, Rule 138, which was inserted on 1/4/2007, also does not contemplate the period within which the developer shall claim refund of tax. Section 35 cannot control section 22. Benefit of beneficial legislation has to be given.
To the SEZ dealers.
My lords, now what happens is, when my lords Justice Kumar's bench considered section 35, it also considered section 10, my lords.
Of the very same act.
Of the very same act.
But this act is not considered.
My lords, but the tax is collected and enforced by me under KVAT Act, my lords.
Maybe if legislation is by the center and it gives entitlement to the SSC, how can that be denied on the grounds which are arise under your state legislation?
My lords, even
One
on.
second. Kindly be seated, be seated. Please be seated. Be seated. I'll hear you. I'll not pass any adverse order without hearing you. Kindly be seated. Your standing up disturbs us. Please be seated. Yes. What she tells, appears to be sensible.
So far as.
Grooming of an advocate is another. That's another aspect which you can tell her, Miss Margaret. But what she says appears to be legally, jurisprudentially sensible. Because before Honorable Justice Kumar, that issue did not crop up at all because it was not a SEZ unit.
It was not.
It was not.
It was.
This is a SEZ unit. Therefore, what Kumar says appears to, does not apply to SEZ unit at all. 12 ಇದೆ ಅದು. 12 itself answers which Madam wanted to tell us. 12 itself, because 6 question of law.
Yes.
12 answer. You have framed the question of law under Karnataka KVAT ನಲ್ಲಿ ಮಾಡಿದ್ದೀರಿ.
Yes.
ಈ aspects ಅನ್ನು consider ಮಾಡಿಲ್ಲ. ಈ aspects ಅನ್ನು consider ಮಾಡ್ಲಿಕ್ಕೆ we need not frame the question. We will say matter is substantially covered by the observations in para 6 questions, para 12 answers. These answers go in favor of the assessee. Therefore, the petition is liable to be rejected.
What happens, my lord, is that if the section 35 is held to be technical in nature, in this context, benefit of that is taken by everybody. So if, because Justice Kumar's judgment proceeds on the basis that there is no distinction on the approach in section 10, which is the substantive section, and section 35 that rules the filing of the returns, revised returns, etc. So therefore, my lords, that is read as a composite scheme. If in this particular case, being an SEZ, the respondent here is entitled to relief, I am in your lordship's hands. But I am aggrieved by the treating of 35 as a technical section, because 35 in fact is substantive when read with 10. That is my only submission.
If we agree your contention,
my lords,
then the state would be controlling what the center has done. It is open, at least to the extent the questions crop up here. 2 legislations are operating.
My lords,
Do you agree with this at least?
there is a certain repugnance.
There is certain repugnance.
Certain repugnance. That repugnance, this honorable court seems to say that since the provision of the SEZ Act is beneficial, benefit should go to the person registered under the SEZ Act. Therefore, my lords, beyond that, my lord, 35 may not be termed a technical provision. That is my only prayer.
You want to say something now? Tell.
My lords,
Which law school you are from?
my lords, I'm from BMS.
BMS.
Yes, my lords. My lords, in this case, centum is referring to section 10(3), whereas under the KVAT legislation itself, under section 22, which clearly enables me being a SEZ unit to claim a refund.
Even under that act?
Even under the KVAT Act itself, my
But
lord. 22, my lords. I have given it in my
in
compilation.
that compilation you have given?
First page of the compilation.
Correct, you are right. Liability to register.
20 deduction of input tax on the first page of my compilation. my lord.
First page itself. 20
20
clause 2.
Clause 2, my lords. Tax paid under this act on purchase of inputs by a registered dealer who is a developer of any special economic zone or an unit located in any special economic zone established under authorization by authorities specified by the central
If
government.
it is a SEZ.
Yes, my lords. If I am an SEZ and if I am purchasing goods from a local registered dealer, which is approved by the authorization, which is used for authorization purpose in the special economic zone, I am eligible to claim a refund under this very own KVAT Act.
There is no limitation?
No, my lords. Now, reading this 2220 subclause 2 with rule 130, my lords. 130A provides the procedure, which is in the next page, my lord.
Correct.
Any registered dealer being a developer of any special economic zone or an unit located in any special
Be
economic
eligible
zone
for
shall be
refund.
eligible for refund of tax paid on any inputs purchased by him.
Subject to?
Now, my lords, if such inputs are purchased for purpose of development, operation, or maintenance, then I am using it for authorization, which is also included in under B and A. Further, my lords, under sub-rule 3, the registered dealer claiming refund or deduction under this rule shall claim refund or seek adjustment of tax paid on goods purchased by him towards any output tax payable by
Why it says section says shall claim refund? Suppose I do not want to claim refund at all.
I
And the
am
legislature say, no, you should eat the cake.
I
May
am
claim
eligible,
refund or seek adjustment of tax paid on the goods purchased by him towards any output tax payable being in the return made under Rule 38, along with statement giving the details of each purchase made by him and the purpose for which it was purchased. In the return made under
yes, my lord.
Rule 38, along with the statement giving the detail, you have to make a claim in the return itself.
My lords, I have to make a claim in VAT 100. I agree, I have not done it in VAT 100, whereas I have done it in my VAT 240. But that does not stop me from claiming my refund, which is an eligible refund under 22. And when Manyata promoter says 20 subclause 2 overrides section 35, then 20 subclause 2 should also override my 10(3) and also section 35 minutes.
That has not been laid down.
Huh?
That has not been considered.
That's
But
only
she's
my
developing,
interpretation.
she's developing based on that,
No, at the admission stage,
requires consideration.
that is my respectful. That's my respect.
It requires consideration.
Obliged.
Huh?
I oblige.
But you argued very well,
Thank you. my lords.
very well. Very good. The revenue has preferred this petition by question of law ಎಲ್ಲಿದೆ ನಿಮ್ದು?
Page 19, my lords, para 8.
By raising the following questions of law. ನೋಡಮ್ಮ, page 19 ದಲ್ಲಿ 1, 2 ಯಾವ್ದು ಬರ್ತದೆ ಇರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ 1, 2, 3. No, 1 and 2 ಅಷ್ಟೇ ಬರ್ತದೆ. 1 and 2. Next paragraph. ಇಲ್ಲ 2 ಅಷ್ಟೇ ಬರ್ತದೆ. Because of her submission.
2 is the one that is
You have to
framed.
restrict it to 2.
I'll restrict it to.
First. Learned counsel Kumari Srimati Vinita appearing for the assessee vehemently argues that the question of law framed as above does not arise for consideration in this petition in view of a coordinate bench decision of this court. Coordinate bench ಇದು? Decision of this court in 2016, 1 TMI 468.
STRP 329 and 488.
STRP
329 of 2014.
329 of 2014. Heard and disposed of on 30 September 2015. Full stop. Next paragraph. Having heard learned counsel appearing for the parties, we are of a considered opinion that matter requires consideration at a deeper level in terms of the above question of law, keeping in view the coordinate bench decision. First, admit. Yes.
Deeply.
Yes, next. Very well.
Great,
Thank
sir.
you.
Thank you.
Some youngsters come with a lot of preparation like this. I feel
Learning,
so-
my lord, from them.
We feel so happy,
My lords.
Alva, regardless of the, result, the way they argue is really appreciable. Very well. Yes, yes, Suryadeva.
My lords.
Ha,
My lords, same issue, my lord. Question of whether input tax at rate of 4% is claimed in the return is the issue over here, my lords, and I'd be relying on
Justice Kumar's
Centum.
judgment.
Yes,
In
What
my
is-
own case, centum, my lord, is there, but centum facts are very peculiar to that case. Centum has been distinguished by at least half a dozen subsequent decisions of this honorable court,
Is it-
and especially in my own case. May I just pass on
What is-
the earlier year's order by this honorable? And this is what the tribunal relies. The tribunal relies on my own case.
ಓದ್ಕೊಂಬರ್ತೀರಾ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಾಕೊಳ್ಳ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋತೇನೆ ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಇಡೋದು ಬೇಡ.
In fact, I wanted to say when my learned friend
Go ahead,
was arguing, Manyata also has been considered in this.
In this judgment.
The subsequent division bench in my own case follows Manyata and other cases, because the point is this one. Section 10, as your lordships have seen, basically says how the tax has to be paid. There is output tax. Output tax is basically the tax that I have to pay on my sales. But the entire scheme of value added taxes, that if I make a purchase, because earlier your lordships are aware under KST, before VAT came, under Karnataka sales tax and all that, it was a multi-point levy. And that was adding to taxes. It was a double effect. So to get over that, VAT came, and subsequently now GST has come. Now the entire concept of value added taxes, that I pay sales tax on my sales. But when I sell something, I would have already paid tax on that. Let us say I'm manufacturing something. I'm a manufacturer.
Biscuit packet.
I'm manufacturing, let's say, some product. To manufacture that product, I need many other products as raw materials, components, and other things on which I would have also paid sales tax. So the entire concept of value added tax and GST is that if I am paying output tax, to remove that earlier multi-point levy, if I'm paying output tax, I automatically get a credit of
Whatever is already paid.
whatever I have paid on the inputs that I have used. If I'm just a trader, let us say of TVs, I would have paid, when I'm buying from the manufacturer, I would have paid sales tax to him. If I would be selling the TV at a profit of 100 rupees, only on that incremental 100 rupees I have to pay, which means when I pay output tax, I reduce the input tax that I have paid. Therefore, the tax is only on the increment of 100. That's the entire concept of value added tax, and that's what section 10 enacts. Says from the output tax, whatever taxes you have paid for your inputs, you reduce it and pay the balance. In some cases like export and SEZ and all that, they get a refund because they are not liable to pay any output tax at all. Now the point is, can that be removed? Can that benefit be taken away? It is not actually a benefit. It is virtually like TDS. For example, under income tax, when our income is liable to tax, I automatically get a credit of TDS that has been deducted by my employer or by my client.
Same idea.
Same concept. This is sales tax, that is income tax. Now, can you say, because by mistake, I have not claimed it in the return of income, can you deny me that benefit, a statutory benefit that has been given? Centum was a peculiar case where they initially filed nil returns. There were some bogus entries, and subsequently, after 2 years, they claimed the return. Only on those facts that case was decided. Now, if your honors, your lordships kindly see TAFE, my own case, a subsequent decision of this honorable court. Para 6, page 9. Because Supreme Court has said input tax credit is something that cannot be taken away. It is virtually right I have unless the department is able to show that the input tax I have claimed is a bogus input tax. Paragraph 6 is where infinite and centum were relied on. Then SSCs relied on Giridharilal Palasmal, a decision of this honorable court, where it says, even if I make a claim before the assessing officer, he is entitled to give that benefit to me under assessment, because entire object is that during the course of assessment, you have to determine what is the actual tax payable or what is the actual refund that is due to the SSC. Now, by mistake, if I have not claimed it in the return, if I have claimed it
That will not bar you from taking the
in
refund.
the assessment, the assessing officer, what is the assessing officer's duty? His duty is to determine the exact tax or refund. Merely because I have not claimed it in the return,
That duty does not
that
cease to
doesn't,
operate.
that duty doesn't stop. That is what this honorable court has said. If my lords kindly turn to
Therefore, section 47(1) was not applicable at all is the version of.
paragraph 11 is where infinite and centum, the earlier decisions, were distinguished. Because Supreme Court in the Daiichi, which is what has been relied on by this honorable court in page 11.
You just look into this judgment. We will also look into.
Says
What it appears to be sensible also. Whatever, it's the duty of the assessing officer himself to refund. If already amount is credited because of this transaction, relatable to this transaction, there is a duty. My not claiming it will not absolve him from discharge of the duties.
What happens is the selling dealer is for the purposes of collection of tax, unique circumstances. He is a private party. He is trading regularly with the assessee. Whether there is a regular nexus, not, he is trading regularly with, he collects tax. He is in that capacity said to be my agent.
He is collector.
He collects tax. It is his duty to deposit. So if that party is a genuine party, filing returns, declaring his income, receiving tax, depositing it, then these, the assessee, the purchasing dealer is completely absolved from the liability. Now I have a duty to tally everything. Whether the input tax that is claimed, the selling dealer has accounted for it, deposited it, because he's deemed that fiction acting on my behalf. If he is delinquent over there, he may have genuinely suffered a business loss, whatever, he may not have done it, I'll proceed against him. But if he is bogus, I have to take other remedies. I may have to invoke section 70, put the burden of proof, etc. For the administration of all this, the filing of returns and for me to tally two numbers appears to be time bound. And this is not merely technical, it is substantive in my process of administration of tax. And therefore, my lords, in a given case where I have received the tax, the error appears to be genuine, in assessment I can catch it, maybe there is a way to account for it. But if the burden, this would, my lord, distort the administration of tax itself, where I file the return, I have a window of 6 months to file a revised return, I call it a mistake. And then at some period of time, I say, okay, I have an expense. It can be, I can book part of it as input tax credit. My lords, as it is, my officers are burdened. It is chaos. Of course, there is sunset on this act. That's another matter. But my lords, the provision under 35 has read with 10 has to be given some meaning as to the period. Even I cannot today wake up and say that, look, I had built an office in 2013. I forgot to claim that as a deductible business expense. Mr. Income Tax Department, central government, kindly refund it. Please set it off against, there is, my lord, time bound. And the statute says for that period, return for that period and revisable within 6 months. That has to be given effect to is my respectful submission, my lords. I'll, of course, I mean, if the coordinate bench is held, I'll make
my own case. That is one. And what my learned friend is saying with great respect may not be correct. He is not my agent.
My agent. He's my agent.
See, state's agent.
No, no, not,
He
not
collects-
their agent also, because
In the sense.
this is a case of sales tax, not unlike income tax, my lord, where TDS, he is deducting tax from my income. Here, my purchasing dealer, I am the dealer here, my lord, before your lordships. I am claiming input tax. Now, my purchaser, my seller, liability to pay sales tax is on his own account, because he made the sale to me.
No, so therefore TDS concept itself is not applicable.
TDS concept, I just made it as a, this thing
No,
saying that
understood. In the
this thing-
sense, he will not be agent of the state also.
It is his liability to pay tax to this thing. He is not an agent.
But
It is his
once-
tax.
But once
It is
you
his
make a
tax.
claim,
Ah.
then with retrospective effect, he can be assumed to be your.
So I can understand what my learned friend is submitting is what your lordships have seen in a case of Ecom Gill. If I am claiming some input tax credit and the department says that the input tax credit you are claiming is of a seller who is bogus, who is not registered, who has not filed returns, and therefore I will deny your input tax
May be
credit.
justified.
May be justified.
But
And that
where
is
there
what-
is nothing like this.
That is what your lordships have referred to Ecom Gill and admitted one matter. That is the case of Ecom Gill. This is not that case. This is a case where my sellers have filed the returns. There is no dispute about that. There is no dispute about my
The
claim for input tax
genuine
credit.
payments have been done.
Genuine
already.
payments have been made. Only reason for denial is that I have not claimed it in the return.
Or revised return.
Or in
Not the revised return. Whether
That need not be. is
whether
your
therefore, that need not be according to me, because according to me, I mean, there are any number of decisions to say returns and all that are machinery provisions. Ultimately, what is the charging provision? Ultimately, you cannot withhold under Article 265.
Only with
Your-
authority of law.
You cannot.
What does it mean? If you say, he gave an example.
Yes.
2013 he did, he forgot to collect it. That may upset the budgetary economics of the country.
Correct.
There has to be some delay latches, if not limitation. That aspect may arise.
Yes, that's why I said centum is a case where this honorable court said because of the delay, first you filed a nil return, then after 2 years, you claim a input tax credit, and therefore centum. That's why centum was distinguished. And there are two other decisions where centum was distinguished, which I will produce on the next occasion when your lordships are. I'll file a compilation so that your lordships can.
What do you-
There are a lot of these matters.
Your note and compilation.
Yes, of all the decisions for and against. Of course, centum is before the honorable.
But you ಹೇಳೋದು limitation ಇಲ್ಲ.
One more thing I'll point out. Following centum, Manyata, MFAR also, a division bench took the same view as centum. That matter, we filed a SLP and the judgment has been stayed by us. Oh,
Centum is not.
centum is not stayed, but MFAR has been stayed. Because
For this
Supreme Court
matter,
in Daiichi says, input tax credit and SENVAT credit are indefeasible rights of an SSC.
No, but that judgment which that gentle lady cited, it says there is no limitation at all.
No, Manyata was slightly different. On
Different.
facts. Manyata also, we appeared, my senior, Mr. Kumar appeared. That also is in, the state has taken it to SLP connected with that's pending. It's coming on board before the Supreme Court and we are appearing there.
When matter is likely to be decided.
Not yet. It's not on board yet. It had come up before the vacation. After vacation, it's not listed yet. So centum, Manyata and all are tagged and coming up before the Supreme Court on and off. We don't know when it will be decided. But I'm just saying that subsequently, these decisions
Are considered.
by other division benches and distinguished on facts.
We'll call this week after next.
I'm sorry.
Week after next, can we call this
Yes,
matter?
yes.
ನೀವು ನೋಡ್ಕೊಂಬನ್ನಿ ಅವ್ರಿಗೊಂದು ಶೇರ್ ಮಾಡ್ಬಿಡಿ ನಿಮ್ ರೈಟ್ ಅಪ್
ಕೊಟ್ಟಿದ್ದೆ.
ಅಲ್ಲ
ನಾನು ಕಂಪೈಲೇಷನ್
ಹಾ ಕಂಪೈಲೇಷನ್
ಕಂಪೈಲೇಷನ್.
call this matter. Any particular date you want? Surnarayana?
Third my lord, February.
3rd February ಹಾಕ್ಬೋದಾ? On 3rd February. Okay.
Great.
Obliged.
Itarani.
my lords. Appearing for the assessee appellant, my lords.
Ha.
Lords, in this case, the issue is there was a intimation passed under 143(1) of the Income Tax Act, my lords. Now, I had to file an appeal before the first appellate authority, Commissioner of Income Tax Appeals. There was a delay of 359 days while filing the appeal before the first appellate authority, my lords. The first appellate authority did not condone the delay. And then the appeal was filed before the second appellate authority, Income Tax Appellate Tribunal, my lords. The tribunal also has not condoned the delay, saying that the assessee has not explained the sufficient cause, my lords.
What is the cost shown?
My lords, the cost shown are 2, my lords.
Take us. Delay ಎಷ್ಟಿತ್ತು?
359 days, my lords.
359 days. Longer delays where you come before us, we have condoned. ಮತ್ ನಿಮ್ಗೆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೇಕು, ಅಸೆಸಿಂಗ್ ಮಾಡೋದು ಬೇಡ ಅಂದ್ರೆ ಹೆಂಗೆ? ಡಬಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಆಗ್ತದೆ ಅದು, ಅಲ್ವಾ? ರಿಮ್ಯಾಂಡ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಅಲ್ರಿ? ಪ್ಲೀಸ್ ಯಾರಿಗೆ ಮಾಡ್ಬೇಕು ರಿಮ್ಯಾಂಡ್? ಫಸ್ಟ್ ಅಪಲೇಟ್ ಅಥಾರಿಟಿ?
You can go to first appellate authority.
Please, Manoj, because both the authorities have dismissed on delay, they've not looked into the merits.
ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಎಲ್ಲಿದೆ?
My lords, page 16.
Which is the question?
My lords, first and second.
Whether there is sufficient cause or not is a question of fact.
My lords,
where is the contra judgment?
My lords, the Supreme Court in case of Hero Vinod held that when the tribunal is not considering the facts properly, one. Second, when the settled principle is not followed by tribunal. Now here there is a settled principle that when substantial justice versus technical considerations are there, my lord.
No, but delay now apex court says is not a question of technical thing. Latest judgment, 29th January 2025 judgment.
My lords, but my facts are there. The reasons, sufficient reasons are given, and that reasons are not appreciated by both the appellate authorities, my lords. And my lords, in AY 2021, another assessment year, same tribunal condoned the delay, my lords, of more than 400 days, my lords. So there's an inconsistency in tribunal decision itself, my lords. The delay in the subsequent year was 484 days, my lords. Which is at page 91, my lords, annexure G. And there, my lords, para 6 and 7, they condone the delay, my lords.
We'll refer it to, send it back to the tribunal, please, for consideration afresh. Please. Appeal by the assessee has raised the following questions as the substantial questions of law. First up, learned counsel, please be seated. Learned panel counsel on request appears for the respondent sole respondent revenue and opposes the appeal, contending that the questions framed do not have substantial elements of law and therefore, first up. Next paragraph. Having heard the learned counsel for the parties and having perused the appeals, we are of the considered opinion that first of the questions framed has the characteristics of the substantial question of law, and therefore appeal merits admission on that basis. First. Next paragraph. At this stage, learned counsel appearing for the advocates appearing for the parties in all fairness submit that the appeal after being admitted need not be kept pending for an indefinite period of time, and that disposal of the appeal on the first question of law would do justice to both the sides. First, we agree with this. First, next one. Learned counsel for the appellant assessee is justified in submitting that ordinarily delay in appeal of the kind needs to be addressed with some amount of leniency, in as much as in several appeals filed by the revenue, that approach has been adopted by this court itself. First, he also adds that after all, condoning delay would not add additional merits to the case of appellant, be it before this court or before the tribunal either. And that dismissing the appeal because delay is not being condoned would cause a heartburn to the assessees. First, we agree with this view. Next paragraph. In the above circumstances, the substantial question of law as to justifiability of not condoning the delay needs to be answered in favor of the assessee, at least to the extent assessee, and therefore we are of the considered opinion that the delay proved in filing the first appeal needs to be condoned, and in the peculiar facts of the case, the matter be remitted to the ITAT for consideration of the appeal on merits. First, ordered accordingly, and appeal is disposed of, keeping open all contentions of the parties. No cause. What have said? Yeah, we should. We'll revert within a few minutes. ಮತ್ತೆ ಅವ್ರು ಹೋಗ್ಬಿಟ್ಟಾರಲ್ಲ
ಶಿಪ್ ಅದು ಕನೆಕ್ಟೆಡ್ ಸೇಮ್ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೇಕು.
ಸೇಮೇ ಇದಾವೆ.
ಸಿಮಿಲರ್ ವೇನಲ್ಲಿ ಎಲ್ಲ
ಅವನು ತರಿಸ್ಬಿಡಿ, ಅದಕ್ಕೆ ಇದ್ರ ಜೊತೆ ಮಾಡೋದು ಬೇಡ. ಈಗ ಈ ಒಂದು ಅಲ್ಲ 1 to 4 ಅಲ್ಲ 1 and 4 ಅಲ್ಲಿ questions do not arise ಅಲ್ಲ are covered by judgment.
Yes, covered by
judgment. 18 and 18.1 and 18.2 ದಲ್ಲಿ questions do not crop up at all.
Yes,
ಆ ಪ್ರಕಾರ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿದ್ದೇವೆ ನಾವು. ಏನಂತ ಎನಿವೆ ಅವ್ನು ಮಾಡಿದ್ರೆ ಸಪರೇಟ್, ಉಳ್ದವ್ ಆಮೇಲೆ ಮತ್ ಮಾಡಿ ಮತ್ ನಾಕಿನ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು.
ರಿಮೈನಿಂಗ್ 4 ಮ್ಯಾಟರ್ಸ್ ಅದೇ ತರ ಯಾವ್ದ್ರಲ್ಲಿ ಏನಾಗ್ಬೇಕು ಅಂತ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡಿ ಸಪರೇಟ್ ಆಗಿ, ಇದು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಆಗಿ ಹೋಗ್ಬಿಡುತ್ತೆ. ಈಗ by mistake of the technical, then it makes no difference. ಅಲ್ಲಿ ಇನ್ನು ಉಳಿದಿದ್ದನ್ನು ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡಿ so that ನಮ್ಮ ಮುಂದೆ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತು. Within a few minutes we are reverting. So
Court officer.
No, 41. 41 still.
ನಮಸ್ಕಾರ ಮೇಡಮ್.
ಗೌರ್ಮೆಂಟ್ ಇಡೋದಕ್ಕೆ ನಾನು ಎಫ್ಐಆರ್ ಆಗಿದ್ದೆ ಈ ಮ್ಯಾಟರ್ ಒಂದು ವಾರದಲ್ಲಿ ಇಲ್ಲಿ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ
ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಕೋರ್ಟಿಗೆ ಬರ್ದೇನೆ ಅಂತ ಆರ್ಡರ್ ಆಗಿತ್ತು. ಅಲ್ಲಿ ನಾವು ಪದೇ ಕೇಳ್ತಾ ಇದೀವಿ, ನೋಡ್ರಿ ಸರ್ ನಮ್ಮ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಇನ್ನೂ ಫೈಲೇ ಕಳಿಸಿದ್ವಿ ಅಂತ. ಅದ್ರ ಜೊತೆ 6/2024 ಕಳಿಸಿದ್ದೀರಿ, ಅದು ಕಂಪ್ಲೈ ಮಾಡಾಯ್ತು, ನೀವು ಕಳಿಸೇ ಇಲ್ಲ. ರಾಜು ಬರ್ರಿ.
$28.
Lordship, in this case, my lord, I have to raise additional substantial question of law, my lord. I pray for time.
2 weeks on request
Please, my lord.
of panel counsel. Okay. 29.
It's 29, my lords. It's transfer pricing matter.
Also,
My lords, I'll file my NOC wakalat in this matter. I've just been instructed to appear in this.
is it? You don't want to continue?
My lords, I will file my,
To appear.
I am to appear.
Timothy, so and so applies for the assessee in the place of Mr. Mallar Rao K, learned counsel Mr. Mallar Rao K, who is permitted to retire from the case.
Lords, may
Registered to print her name.
my request, my lordships may kindly consider to admit, my lords, because it's a similar issue your lordships are hearing.
We have already,
Please, my
we are
lords.
considering that
Please.
one, na? We'll admit this, sir,
Well,
one time.
I don't have the benefit of the papers, my lord.
Or you can set of papers.
Please, my lords.
All good. Call after 2 weeks. Okay.
Obliged.
Call next week, Maranand.
Please.
Call next week.
Okay.
Okay. Ah,
486 of 23 connect ಆಗ್ಬೇಕು ಇದರಲ್ಲಿ.
34,
ಹಾ 34.
ಅದು admit ಆಗಿದೆ ಏನು?
ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. Call this matter along with ITA number. Okay.
486 of 23 minute.
486 of 23.
Yes, ma'am.
Okay. Ah. Ah.
The respondent numbers 1 and 2, Your Honor. Your Honor, my lord,
31.
3-4 days time may be given.
31.
For respondent numbers 1 and 2,
Ah.
sincere apologies, my lord, 3-4 days time may be given. We'll do the final hearing.
41.
Respondents 1 and 2.
Mr. Kasturi.
I am appearing for the petitioner in this case. Lord, the auction failed. Second bidder also has taken the money back. I am now, I have paid 15 crores out of a one-time settlement.
You are for respondent.
Respondents 1 and 2.
When do you?
Matter, my lord,
4
is
days.
3-4
on a
days.
very short point.
ಅದೇ ಅವರು ಯಾರೋ ಒಬ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಡೇ ಆಫ್ಟರ್ ಅಂತ
ಇಲ್ಲ, Wednesday Supreme Court ಅಲ್ಲಿ ಇದೆ, my lord.
Thursday or Friday is fine, ma'am.
Wednesday I am in the Supreme Court.
ವೆನಸ್ಡೇ
A short.
Wednesday ಬೇಡ.
ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ we can ಮಂಡೇ ಹಾಕೋಣ.
Monday ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಬರ್ಕೊಳ್ಳಿ.
Almost senior counsel is next court.
ಹಾ
Only pass over, short pass over.
ಅಲ್ಲ ಅವ್ರ ಟೈಮ್ ಬೇಕಂತಲ್ಲ, ಈಗ ಅವ್ರ ಅಪೋನೆಂಟ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಮಂಡೇ ಹಾಕೋಣ ಅಂತ. ಟೂ ಪಿಟಿಷನ್ ನಂಬರ್ 2ಗೆ ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಪಾಸ್ ಓವರ್.
Pass over, my lord.
ಪಾಸ್ ಓವರ್ ಮಿಸ್ಟರ್ ಕಸ್ತೂರಿ, ಅದ್ಯಾರೋ ಇನ್ನೊಬ್ರು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರಂತೆ ನೋಡೋಣ.
ಆಯ್ತಾಯ್ತು.
ಓಕೆ. ಹಾ ಸಂದೇಶ್
Pass over.
ಪಾಸ್ ಓವರ್. ಆಲ್ ಹಾ 42 ರೆಡಿ. 42
Lords,
ಏನಿದು ಬ್ರದರ್?
the land grabbing matter, my lords, conviction.
ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆಯಾ?
Please, my lords.
ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ.
Please, my lords, conviction. My lords, only on the ground that, my lords, the annexure B, Maas are conducted by the
Annexure
B, my lords.
B.
B, my lords.
B for Bali.
B.
Bombay.
Please, my lords.
ಹಾ
Page number 17, my lords. Conducted by the respond number 2, my lords.
17. ಟೇಪರ್ ಕಾಪಿಯಲ್ಲಿದೆ.
Next page, my lords. 18, my lords. Lords, 2018ನೇ ಇಸ್ವಿ ಫೆಬ್ರವರಿ ದಿನಾಂಕ 15ರಂದು ಸೊರಬ ತಾಲೂಕ್ ಕಸ್ಬಾ ಹೋಬಳಿ ಮನ್ಮನೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 70ರ ಚಿಕ್ಕಸ್ವಿ SF ಅರಣ್ಯ ಪ್ರದೇಶದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿನ ಕೆಂಪಪ್ಪ ಬಿನ್ ಬಸವಣ್ಣಪ್ಪ ಅವರ ಅನಧಿಕೃತಿ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವ ಸ್ಥಳದಲ್ಲಿ ಕೆಳಗೆ ಸಹಿ ಮಾಡಲು ಇಚ್ಛಿಸಿರುವ ಪಂಚಾಯತ್ದಾರ ಸಕ್ಷಮದಲ್ಲಿ ಹೇಳಿ ಬರೆಸಿದ ಸ್ಥಳ ಮಂಜೂರು ಏನೆಂದರೆ, ಈ ದಿವಸ ಚಿಕ್ಕಸ್ವಿ ಶಾಖೆಯ ಉಪವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿಯು ಸಿಬ್ಬಂದಿಯು ಮೇಲ್ಕಂಡ ಸ್ಥಳಕ್ಕೆ
ಬಂದು ನಮ್ಮಗಳ ಪಂಚಾಯತ್ದಾರರನ್ನಾಗಿ ಸ್ಥಳಕ್ಕೆ ಬರಮಾಡಿಕೊಂಡು ವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿಗಳು ಶಿರಾಳಕೊಪ್ಪ ವಲಯರು ಈ ಕಚೇರಿಯ ಆದೇಶದಂತೆ ಅರಣ್ಯ ಒತ್ತುವರಿ ಪ್ರಕರಣಗಳನ್ನು ಮಾನ್ಯ ಕರ್ನಾಟಕ ಭೂ ಕಬಳಿಕೆ ವಿಶೇಷ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂ ಕಬಳಿಕೆ ನಿಷೇಧ ಕಾಯ್ದೆ ಅಧಿನಿಯಮದಡಿಯಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಲು ಸೂಚಿಸಿರುವ ಮೇರೆಗೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲು ಸಹಕರಿಸುವಂತೆ ನಮ್ಮಗಳನ್ನು ಕೇಳಿಕೊಂಡ ಮೇರೆಗೆ ಪಂಚಾಯತಿದಾರರಾದ ನಾವುಗಳು ಇಲಾಖೆಯವರೊಂದಿಗೆ ಸೇರಿಕೊಂಡು ಅಗತ್ಯ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಮೇಲ್ಕಂಡ ಸ್ಥಳವನ್ನು ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ನೋಡಲಾಗಿ ಸದರಿ ಸ್ಥಳವು ಸರ್ವೆ ನಂಬರ್ 70ನೇ ಮನ್ಮನೆ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದಾಗಿದ್ದು ಚಿಕ್ಕಸ್ವಿ SF ಅರಣ್ಯ ಪ್ರದೇಶಕ್ಕೆ ಸೇರಿದಾಗಿದ್ದು ಪಹಣಿ ಪ್ರಕಾರ ಒಟ್ಟು ವಿಸ್ತರಣೆ 57.12 ಎಕರೆ ಇದ್ದು ಮುಂದುವರೆದು ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಕೆಂಪಪ್ಪ ಬಸವಣ್ಣಪ್ಪ ಅಂದಾಜು ವಯಸ್ಸು 52 ಜಿರ್ಲೆಕೊಪ್ಪ ಗ್ರಾಮದವರು ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಅರಣ್ಯ ಒತ್ತುವರಿ ಮಾಡಿದ್ದನ್ನು ಕಂಡು ಒತ್ತುವರಿದಾರರಿಗೆ ಸದರಿ ಒತ್ತುವರಿ ಬಗ್ಗೆ ವಿಚಾರಿಸಿ ಕೇಳಲಾಗಿ ಅವರುಗಳು ಅಂದಾಜು 15 ವರ್ಷಗಳಿಂದ ಒತ್ತುವರಿ ಮಾಡಿ ಜೋಳದ ಬೆಳೆಯನ್ನು ಬೆಳೆಯುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿದ ಮೇರೆಗೆ ಸದರಿ ಸ್ಥಳದ ಚಕ್ಕುಬಂದಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಪೂರ್ವ ಪಶ್ಚಿಮ ಹಾಗೂ ದಕ್ಷಿಣಕ್ಕೆ ಅರಣ್ಯ ಪ್ರದೇಶ, ಉತ್ತರಕ್ಕೆ ಅರಣ್ಯ ಇಲಾಖೆಯ ಸೋನ್ಸೋ ಇರುತ್ತದೆ. ಇಲಾಖೆಯವರು ನಮ್ಮಗಳ ಸಮಕ್ಷಮದಲ್ಲಿ GPS ಸಹಾಯದಿಂದ ಸೋನ್ಸೋ ಒತ್ತುವರಿ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 4 ಎಕರೆ 8 ಆಗಿದ್ದು ಸದರಿ ಆಸಾಮಿಯು ಈ ರೀತಿ ಅಕ್ರಮವಾಗಿ ಅರಣ್ಯ ಪ್ರದೇಶದಲ್ಲಿ ಒತ್ತುವರಿ ಮಾಡಿರುವ ಬಗ್ಗೆ ಕರ್ನಾಟಕ ಭೂ ಕಬಳಿಕೆ ನಿಷೇಧ ಅಧಿನಿಯಮದಡಿಯಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸುವ ನಿರ್ಣಯ ಕೈಗೊಳ್ಳಲಾಯಿತು. ಇಷ್ಟು ಹೇಳಿ ಬರೆಸಿದ ಮಹಾಜರನ್ನು ಸ್ಥಳದಲ್ಲಿ ಓದಿಸಿ ಕೇಳಿ ಸರಿ ಇದೆ ಎಂದು ಒಪ್ಪಿ ಸ್ಥಳದಲ್ಲಿ ಪಂಚಾಯತ್ದಾರರು ಮಹಾಜರ ಕ್ರಮಕ್ಕೆ ಸಹಿ ಮಾಡಲು ನಿರಾಕರಿಸಿದ್ದರಿಂದ ಇಲಾಖೆಯವರಾದ ನಾವುಗಳು ಪಂಚಾಯತ್ದಾರರು ಮಹಾಜರ ಕ್ರಮಕ್ಕೆ ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿರುತ್ತೇವೆ. My lords, without giving the notice.
But you refused to sign. We were there.
ಅಲ್ಲ, ನಮ್ಗೆ ವಿಷಯನೇ ಗೊತ್ತಿಲ್ಲ. We are not encroach the property, my lords.
My lordship, in this LCR
Even
is
my
been
lords-
required because there are the certain document which is produced by the state also. And he is admitted in the cross examination, he has possessed the property illegally. It is admitted by themselves.
It's admitted there only.
Yes, my lordship.
Call for LCR immediately from the special court. First, post this matter.
And it's a forest land, my lordship.
After receipt on Barbecue, immediately on Tuesday. 28. First off. The registry of the special court shall forward the LCR stroke TCR forthwith. Okay. That's not.
Earlier entry
No,
model
entry matter ಇದೆ ಈಗ.
ಇತ್ತು, but the time being, my lords, not extended.
Entry matter continue ಮಾಡನಂತೆ. Entry matter to continue from this day till 28/1.
Much.
Okay. ಅವ್ರಿಗೇನೋ ಕನ್ಫ್ಯೂಷನ್ ಇದ್ರೆ ನಾ ಮಾಡಿದ್ ನಿಜ ಇದೆ ಅನ್ಕೊಂಡಿದ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು, ಅದ್ರ ಮೇಲೆ ಆಗ್ತದೆ. ಬಟ್ ಜಸ್ಟ್ ಎಕ್ಸ್ಪ್ಲೋರ್ ದಿ ಕನ್ವಿಕ್ಷನ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಆ ಲ್ಯಾಂಡ್ ಅನ್ನು ಅವ್ರು ಬಿಟ್ಕೊಡ್ತಾರೆ ನಂಗಿದ್ರೆ.
But this is a forest land, my lordship.
Therefore we'll give back the land to you.
Please, my lordship.
We are just thinking in that direction. Just think about that also.
We are not encroaching the land, my lords. Before that, my lords, ಅವರೇ ಹೇಳ್ತಾರೆ 15 ವರ್ಷದಿಂದ ಬೆಳೆ ಬೆಳೀತಾ ಇದಾರೆ ಅಂತೇಳಿ. Till today they have not issued any notice to the petitioners.
Back notice ಬೇಕು.
No.
ಲಾದಲ್ಲಿ ನೋಟಿಸ್ ಬೇಕಾಗಿಲ್ಲ. If you are encroaching,
They
you are
have
liable.
made in the idರಲ್ಲಿ ಏನು.
No, you show what is your title to that. They need not show at all. Yes. ಆಕ್ಟ್ನಲ್ಲಿ ಹಂಗಿಲ್ಲ. ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ವಿ ನಾವು. Yes.
Section 11, it is they have accused us.
That's what you should show, that you are in the lawful possession of the property. Okay. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಒಳಗೆ ಹೋಗ್ತಾನೆ ಅಷ್ಟೇ. Yes. You ask your client, brother, you ask your client whether he is ready and willing to quit it at once. Okay? We may consider that.
Please.
Okay. ಏನಿದು ಶಿವಕುಮಾರ್?
We had filed objections, which is one of the procedure to be followed. And in the objections, we had produced Xerox copies and notarized copies of the sale deeds which we had. We also brought to the notice of the court that earlier proceedings have been disposed of and the proceedings are dropped in respect to the very same grant. We are purchasers of the property for more than 1962 sale deeds are there.
1962.
62.
Very same property.
Yes, my lord, the adjacent properties, a layout was formed and then their sales were made.
You bought, what is that property? You formed the layout.
I didn't form.
Who are you?
Persons who, I am a purchaser of the property.
Purchaser of entire
Purchaser
property?
of a portion of the property.
Best of the measurement.
Yes, my lord, 80 feet, in survey
Site.
number 80.
Site,
Yes, my lord.
Huh?
It's a site, my lord. And earlier orders were dropped in so far as.
Admission ಬಂದದಾ?
ಹೌದು.
After service ಆಗಿ?
ಆಗಿದೆ, service ಆಗಿ.
ಮತ್ತೆ LCR ತರಿಸಿ.
Please, my lord.
ಏನಿದೆ proceedings?
They are
Till it is
asking for
pending now.
bashing
But
of
proceedings are pending. Pending.
You file
220.
covered by our judgment na? ನೀವೇ ಮಾರ್ಕೆ ಮಾಡಿ.
ನಾವು ನಮ್ದ್ರಲ್ಲಿ
ಆ ಪ್ರಕಾರ ಮಾಡಿ ಕಳಿಸಿ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಕೊಡಿ ಅಂತ ಕೇಳಿ.
ಅದು ಕೊಟ್ಬಿಟ್ರೆ ನೀವು ಕೊಡಿ.
ಆಯ್ತು, ಕೊಡ್ತೀನಿ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಕೊಡಿ, ಸೇಲ್ ಡೀಡ್ ಇದ್ದು.
ಸೇಲ್ ಡೀಡು ಕೊಡ್ತೀನಿ. ಅವ್ರದೇ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡ್ರಾಪ್ ಮಾಡಿದ್ದಾರೆ.
ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಡಿ.
ಆಯ್ತು.
ಅಲ್ಲಿ ಪರ್ಸನಲ್ ಅಪಿಯರೆನ್ಸ್ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಬೇಡಿ.
That's what
Let him
many
seek,
of my lordship.
ಏನ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಂಡಾಗಿದೆ ಏನೋ?
ಕಾಪೀಸ್ ಎಲ್ಲ ಸರ್.
ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಂಡಾರ?
ಕಾಗ್ನಿಸೆನ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಇನ್ನ.
Only notice is challenging the order.
We have to file objections. Objections are rejected.
ವಜಾಗಿದ್ ನೀವು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಿ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ
ಅಷ್ಟೇ, that's the only reason.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
220.
Let it be reheard, that's all.
ಅಷ್ಟೇ, ದಟ್ಸ್ ವಾಟ್. ಬರ್ಕೊಳ್ಳಿ, ಕೂತ್ಕೊಳ್ಳಿ
Please.
ಅದೇ 9(3) ಕೆಳಗಡೆ ಹಾಕಿದ್ದನದು ಡ್ರಾಪ್ ದ ಪ್ರೊಸೀಡಿಂಗ್.
9(3)
ಪ್ರಾವಿಸೋ.
Yes. There are two item properties, my lord, which I showed it in the schedule. And they are converted also.
Petitioner who figures as an accused in the proceedings of the court below, of the special court, is knocking at the doors of writ court for assailing the order dated
4/1/2024.
4/1/2024. 4/1/2024. Whereby his application for dropping off the proceedings in LGC bracket nalli P bracket complete number 815/2019 has been negatived. First, learned counsel appearing for the petitioner submits that if certain documents were available on record in the form of photostat copies, the special court could have indicated its intent to have certified copies of the same. Semicolon. That having not been done, there is error apparent on the face of the impugned order, warranting its invalidation. First off, he also submits that initiation of criminal proceedings against a citizen cannot be done as a matter of course. And in support of that, he presses into service the apex court decision in Pepsi Foods versus so and so, so and so. Next paragraph. Learned AGA appearing for the
1 and 2.
respondent 1 ಅಷ್ಟೇ. 2 ಯಾರಿದ್ದಾರೆ?
ಅದು
He is the person who filed the private complaint.
that is 3.
Oppose,
That is 3. 2 is KLGP, registrar of KLGP.
No,
no, that's not.
2 is Hemant Raj.
He is a private complainant.
Private complaint.
After service of notice, the first respondent, Tahsildar, is represented by the learned AGA. Full stop. The second respondent, Hemanta Raju, despite service of notice, has chosen to remain unrepresented. and that would not deter the court from adjudging the cause brought before it in accordance with law. First off, learned AGA vehemently resists the petition making submission in justification of the impugned order. Please be seated. And the reasons on which it has been constructed. First, she points out that the jurisdiction of this court is a limited supervisory jurisdiction under Article 227, Article 226 having been ornamentally employed in the petition. And therefore, court should loathe to interfere. First, having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence in the matter, in as much as there is force in the submission of learned counsel for the petitioner that he would place certified copies of the sale deeds of the year
1962-63,
and also the proceeding sheet of earlier proceedings that came to be dropped eventually by the very same court. First off, ideally speaking, petitioner who had pressed into service application seeking dropping of the proceedings under section 9(3), under the provisions of section 9 of 2011 Act, ought to have produced the certified copies of these documents. First off, at times, such things are not done. And in that event, the special court ought to have asked him to produce the certified copies. First off. Next paragraph. There is force in the submission of learned counsel for the petitioner that initiation of criminal proceedings, that too before a special court established under the special statute, that is 2011 Act, is a serious matter. As observed by the apex court in Pepsi Foods Supra. First off, where proceedings are initiated and on the service of process, the accused appears before the court on his own and seeks a discharge by moving application of the kind, the trial court cannot be very restrictive in its approach. First off, it has to bear in mind that one has to bear in mind that there are special proceedings brought before the special court. First off, this approach is not reflected in the impugned order when it ought to have been. First off, that constitutes added error apparent on the face of the record, warranting interference of this court. First off, merely because this court is arguably exercising limited supervisory jurisdiction constitutionally vested under Article 227, one cannot argue that court should not interfere even if there is error apparent on the face of the record. First off, writ courts cannot send the aggrieved party empty-handed when there is demonstrable injustice to him. First, a contra submission would be affecting the credibility of the people in the judicial process and therefore cannot be countenanced. First, in the above circumstances, this petition is favored in part. Semicolon, a writ of certiorari issues, quashing the impugned order, and matter is eventually remitted back to the portals of the special court for consideration afresh, keeping open all contentions of the parties. First, next paragraph. The observations herein above made, being confined to consideration and disposal of this case, would not influence the fresh decision making in accordance with law. Obliged, please. No course.
Lords, a small but a very interesting point, my lords. Of course, I don't think that
constrained to seek one final adjournment, my lord.
But one adjournment.
Final adjournment,
Yeah, dating.
lords, either Friday or Monday, my lord, as convenient to your lordships.
Maybe
Lords,
Monday hack.
I have no difficulty. Lords, what happens? There is one bidder who bids at 12.88 crores. He does not, he deposits 25%, but does not take this bid forward. But that auction proceedings is challenged before this honorable court. This honorable court grants an interim order saying that the confirmation of sale is stayed subject to deposit of 1 crore. 1 crore is paid once deposited. Interim order was in force. The first bidder says, no, I don't want to participate in this bid. What the bank does is, it issues a letter of confirmation when the interim order was still there to the second bidder. First bidder is gone.
Identical matter, eitherly. Call this matter along with that. We are treating the very same matter.
Lords, I just wanted to say this, my lords. 9-3 because
No, it cannot be sent to the second bidder.
Lords, that
Fresh bidding has to take, auction has to take.
9-3, rule 9-3 is very explicit. Lords, I should appreciate, lords, the legislators' wisdom, the manner in which they have arranged these
Structured it.
provisions, very succinctly laid. At the stage of rule 9-3,
Read. How it reads.
lords, security, I'm sorry, Surface Act.
Rules.
Because I was going through it, is very beautifully worded.
No, the parliamentary legislations.
Yes.
Compared to provincial legislations, qualitatively they are superior. Because they gain lot of experience throughout the country.
Yes.
That experience and the wisdom gained from experience they
Is
infuse in the draft
what
policy.
emanates in the nature of this. Lords, rule 9, time of sale, issue of sale certificate, delivery of possession, etc. 9-3.
The asset.
On every sale, my lords, section, not section 9-3, my lords, rule 9-3 of the security interest rules. Adalari.
You are right. In the event of possession.
Lords, on every sale, rule 9-3, my lords, of the security interest rules 2002. Idin chur kodi idna, ee book kodi.
2.
Sorry.
Copy good.
On every sale of immovable property, the purchaser shall immediately on the same day or not later on the next working day, as the case may be, pay a deposit of 25% of the amount of the sale price, which is inclusive of the earnest money deposit, if any, to the authorized officer conducting the sale. And in default of such deposit, the property shall be sold again.
Therefore, you cannot call the next in line at all.
That's all. This is essentially, my lord, what happened before Orissa High Court, the same question
Otherwise,
came up.
we will be bruising this part of the
Yes,
section.
that's the only question.
How courts have considered.
Lords, the division bench of Orissa High Court has taken, of course, a Supreme Court has also dealt with this very clearly, saying that once rule 9-3 is not crossed, then the mandate is you will have to put the property for re-auction. But a similar question came up before a division bench of Orissa High Court, exactly the same situation, where the second bidder was called upon after the first bidder said, I did not want to participate. Then the question was as to whether it would be permissible. While interpreting this very phrase, shall be sold again, the Orissa High Court said that in their wisdom, they have already said that there is no question of hangovers. You will
It
have to
cannot
stop there and start afresh.
Even otherwise, it cannot be.
It cannot be done. So
It
any
cannot
day,
be.
my
It
lord,
appears to be that. Otherwise, great injustice would be,
In
suppose.
fact, my lord, may I submit
First
this?
bidder, second bidder. This is what the Mr. Murthy was
My lord,
saying.
second bidder has also failed. Second bidder also failed. He paid the money, he withdrew. He has paid about 11 lakhs, 11 crores, and then got this money back.
That's
So
taken his
I
money
have
back, of
paid
course.
on one-time settlement, 15 crores I have deposited.
Lords,
They
what
don't want
happened?
to give it to me. I want to get it. I am only a guarantor, not the borrower.
Yes.
I am
That's
being
what-
harassed like this.
Lords, what happened? The DRT set aside on the same ground, saying that there cannot be, you cannot call upon the second bidder. Then we submitted for one-time settlement. This sale is for about 11.6 crores. The first bid was for around 12.8 crores. Though the letter of confirmation was issued saying that the letter of confirmation is issued to the second bidder to match the bid of the first bidder.
First bid it
But
should
they
be.
did not honor that first.
Did not do that.
Yeah, they did not do. So then what happened after the DRT set aside the order, since there was no interim order, we submitted our proposal for one-time settlement for 21 crores. Whatever they have recovered is 11.6 crores, out of which 15 crores is paid.
Paid.
No interim order was granted at any stage. But the DRAT, my lords, now says that after all, it's a sales certificate, you cannot independently challenge it and is dismissed or and is allowed the appeal. DRT's order is upset by the DRAT.
Okay.
But one more question, my lords, is of course a serious issue is because this issue came up for consideration in that Surinder Singh's case, 1995 Supreme Court, which said if an order of stay is granted, the injunction doesn't operate against the party alone, but this is
Third party is.
no, it is an order which operates against the court to take cognizance of the facts which is in violation of that order.
Not
That
in
was, of
rem-
course, confirmed, my lords, in subsequent judgments in Withdrawal case and then Jihal Tanti's case. In between, there was only one judgment, my lords. I am unable to recollect. Justice Thakur was heading the bench, took a different view, saying that even if a sale has taken place in violation of the interim order, that does not prohibit him from coming on record, because it would not. Then, of course, that came up for consideration subsequently in Jihal Tanti's case. Jihal Tanti then distinguished, saying that there are two earlier judgments, that is Surinder Singh's case and Withdrawal, which says that once an interim order is granted,
It operates
anything
against the court also.
it's against the court.
Unless court says
Yes.
operates inter partes.
Inter partes. A very interesting philosophy, because this is something which I find in Surinder Singh's case.
There is one judgment of English court which says res judicata is not only inter partes.
Yes,
It operates against the court also.
court also.
There's one lone judgment like that, which I read.
Not that I personally feel, my lords, that I have read the judgment. I'll also place it. The bar under section 11 and the bar under the other rules. You know, there are two provisions, section 11 and section 12. Section 11 is res judicata. Section 12 is where the suit is barred by other provisions of the Code of Civil Procedure. The distinction was drawn, saying that section 11 operates against the court. Once the ingredients of section 11 is established, the bar operates against the court. But section 12 is concerned that operates against a party.
Parties alone.
That is the distinction. That's how.
Correct.
Yes.
Next week you are doing that. Step
ಅಷ್ಟೇ ಅದು.
point ಇದರಲ್ಲಿ.
That's the crux.
Monday ಆಗ್ಬೋದು sir.
ಇದಿಷ್ಟೇ ಪಾಯಿಂಟ್ ಕಸ್ತೂರಿ ಅವರೇ.
ಅಷ್ಟೇ ನಾನು I am first petitioner. I have deposited 15 crores.
Lords, one more
As
thing. What
against
happens
the
is,
value of 11
Yes.
crores only.
this probably requires one observation also when the matter is coming up. The statute provides maximum extendable period up to 90 days. Whether interim order is there, not there, that exemption is not there under the scheme of 9.4 and 9.5. Here, the balance was paid after 4.5 years. Even assuming there is an interim order, not because the law, that maxim which says that impossibilia general is that maxim which came up for consideration where the holding of the elections, they said, even if an impossibility arises, the mandate under law doesn't get watered down. Mandate will still have to be followed, because that's how. Of course, that
But
a little
maximum-
distinction what we find in Indoor Development Authority, where they said that
Impossible, make 24.
yes, impossibly, yeah. the doctrine of impossibilia. But the constitution bench has taken the view while dealing with the question, because that was a case where the Gujarat Assembly was not constituted. Presidential election was in the annual. The question came up, it was in reference by the president, whether in the absence of Gujarat Assembly being constituted, whether the elections to go on. The Supreme Court, though, upheld that impossibility is one of the conditions on the basis of which the performance can be dispensed. But once the law steps in with a mandate, then you cannot dispense.
That's right. All these maxims
Yes.
are subject to legislation.
Legislations.
If the legislation says contra, then but in English law, Maxwell treats this, and Broom on legal maxims. He also treats. In many countries, a condition incapable of compliance is treated as having been dispensed with.
Yes.
In English law and colonial law of the colonial countries, the condition is deemed to have been complied with. This is the difference. In fact, very beautifully, Crace on statute deals this aspect of the matter. Dispensing with a condition is one thing. Deeming compliance is
another thing.
Another. That way. There are some nuances.
Such a huge difference.
That's what. But to look at, they appear to be very
Miles,
simple.
the terminologies appears, but it's miles apart.
Miles apart.
Miles. Grateful.
Next week, Madi. Now you have heard them.
Yes.
ಇದರಲ್ಲಿ ಏನಿಲ್ಲ ಸ್ವಾಮಿ. I had deposited 15 crores already.
To continue. Call
Monday.
Date ಹೇಳಿ. ಯಾವ ಡೇಟ್ ಬೇಕು?
Monday, my lord, if it is not otherwise inconvenient.
ನೋಡಿ ಮಂಡೇ ಮ್ಯಾಟರ್ಸ್ ಭಾಳ ಇದೆ. ಥರ್ಸ್ಡೇ ಹಾಕ್ಬೋದು.
Very well.
ಥರ್ಸ್ಡೇ ಥರ್ಸ್ಡೇ
ಈ ಥರ್ಸ್ಡೇನಾ?
23rd ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು.
ಓಕೆ. ಅಲ್ಲ 30th. All right. Okay. Entry more to continue. Till then. ಮಾಡ್ಸಿರ ಈಗ ಅವ್ರಿಗೆ ಅವರು ಇದ್ದಾರೆ. ನಾನು ಮತ್ತೆ ಕುಲಕರ್ಣಿ ಗೊತ್ತಾಗಬೇಕಲ್ಲ.
ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
ಸರಿ, ಇದು ಮಾಡಿಸ್ಬಿಟ್ರಾ? ಎಷ್ಟು
ಹೇಳ್ತೀನಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 1, substantial question of law does not arise.
ನೋಡಿ, ಈ ಲಿಸ್ಟ್ನಾಗೆ the appeal is preferred by revenue by framing the following question as the substantial question of law. ಎಷ್ಟಿದಾವ್?
3 ಇರ್ಬೋದು.
Following questions as the substantial questions of law. ಅವನ್ನೆಲ್ಲ reproduce ಮಾಡಿ. Next one. Learned counsel appearing for the assessee submits, and we agree that these questions do not crop up in the fact matrix of the appeal in question.
From the impugned order.
Question in which the order is impugned. First, in the above circumstances, this appeal is liable to be and accordingly rejected. Okay.
1.1 covered.
Covered by judgment ಆಗ್ತದಾ?
Yes, madam.
ಅಲ್ಲಿ ನೋಡಪ್ಪ. The substantial question, substantially, the fact matrix of this appeal is does match with that of our judgment.
Earlier order ಒಪ್ಪಿದ್ದೀನಲ್ಲ ಅವಾಗಲೂ.
ಹೌದು, ಆರ್ಡರ್ ಹೇಳ್ಬೇಕು.
Your lordship, earlier order ಅವಾಗಲೇ ಹೋಗಿದ್ದೀಯ ಸರ್.
Earlier order of
Justice Vishwanath Shetty, 2006
coordinate bench judgment of 2006, particularly PVSJ.
Yes, ma'am.
PVSJ. Full stop. In view of that, appeal is liable to be rejected and accordingly it is. Okay.
1.2 same order.
1.1, 1.2 same order.
Same order.
All right.
1.3 substantial question of law does not arise.
1.3 same.
1.3 same.
Not 1.3 is as per 1.1 as per 1. Yes.
Please.
ಒಳ್ಳೇದು ಮಾಡಿ ಎಲ್ಲ ಬಂದ ಹೌದು. ಯಾವ ಫಸ್ಟ್ ಎಲ್ಲ ಮುಗಿದ ಹೊಲ್ವಾ? ಆಲ್ ರೈಟ್.
What is the note before?
ಸರ್ ಇದು 42 ಡೇಟ್ ಕೊಟ್ರಾ LCR ಅಂದ್ಬಿಟ್ಟು ಡೇಟೇ ಕೊಟ್ಬಿಟ್ರಾ ಅಷ್ಟ್ರಲ್ಲಿ LCR ಬರುತ್ತಾ ಸರ್ LCR ಅಷ್ಟ್ರಲ್ಲಿ ಬರುತ್ತಾ ನಿಮ್ಮಿಂದ ಹೋಗುತ್ತಲ್ವಾ ರಿಕ್ವಿಸಿಷನ್ ಇಲ್ಲಿಂದ ಹೋಗುತ್ತೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?